All right, we are recording now. Good morning, and good morning, members of the Joint Judiciary Committee and members of the public. Good to see you here this morning on this Tuesday, September 13th, the second day of the second interim committee for the Joint Judiciary. We have a great and busy morning ahead of us, and so we'll go ahead and get started with our topic of trespass. For members of the audience and the Joint Judiciary Committee, we will take the bills in the following order, and we will generally take them separately and take public comment separately on each bill. And they will be heard with LSO Bill Draft 109, 111, 108, 110, and 112. I'll repeat those for those watching and here in the audience. 109, 111, 108, 110, and 112. So just a matter of being able to follow along for everyone watching here on this very exciting topic. And so we'll start with a brief overview from LSO of LSO Bill Draft 109. And that is Adjacent Land Resource Data Trespass Appeal.
Thank you, Madam Chairwoman. David Hopkinson, the Legislative Service Office, reviewing 23 LSO 109. This bill draft, quite simply, what it does is on page 3, the section 2, it repeals Wyoming Statute 63414C and 4027-101C, which are listed in the staff comment. Those sections were held to be unconstitutional previously in the 10th Circuit in 2017-2018. And so all this draft does is repeal those sections, and the changes that are seen on page 2 are simply conforming amendments accounting for the repealer of those 2 sections within Wyoming statute. And what those were addressing was specifically trespass to unlawfully collect resource data. When a person trespassed or crossed private land to access adjacent land where they collected resource data without having written or verbal permission or an ownership interest in that property. With that, I'd stand for any questions.
Thank you. Any questions for Mr. Hopkinson? Are you awake? All right, thank you. Thank you, Mr. Hopkinson. All right, well, that will go to public comment. Any public comment on this bill? All right, seeing none, public comment is closed. Committee, back to you.
Move the bill.
Moved by Senator Cost. Is there a second? Seconded by Senator Kolb. Discussion? Committee, I'll just remind you that this bill was a very controversial issue that went through the legislature for many, many years. Mr. Magagna, who is here in the room, recalls some of that. I was even before my time in the legislature, and I think most of us here on this committee here today, in fact, I believe it was actually before our time. Notably, and I think interestingly, we were challenged by the state of Wyoming. This legislation was challenged by those interested stakeholders, those plaintiffs. They sued us in federal court and we lost. That the law was obviously unconstitutional, and that's the bill draft here today. I think it's important to recognize, and one that's commonly not shared, is as a result of that unconstitutional determination, the federal judge in that case ordered the state of Wyoming to pay attorney fees to the plaintiff's lawyers, all of which were primarily out of state. The state of Wyoming paid over $600,000 in attorney fees to out-of-state lawyers for passing an unconstitutional law. That's just an important piece of information, I think, as we move forward, and how important it is for us to carefully craft legislation. And when there are concerns about it being unconstitutional, to recognize that there are real consequences to that, and to the taxpayers of Wyoming, who of course paid for the legislature's passage of that unconstitutional law. Roll call vote.
Senator Cooper?
Aye.
Senator French excused. Senator Kolb?
Aye.
Senator Cost?
Aye.
Representative Crago? Representative Larson?
Aye.
Representative Oakley?
Aye.
Representative Provenza?
Aye.
Representative Washut?
Aye.
Representative Rodriguez Williams?
Aye.
Representative Yin?
Aye.
Representative Zwanitzer. Co-Chairman Olson. Chairman Nethercott. That passes.
Well, we've started very constitutionally this morning, committee. It's good for us. With that, we will go on to LSO Bill Draft 111, Version 4, defining aircraft for purposes of hunting prohibitions. Mr. Hopkinson?
Thank you, Madam Chairman. This bill I apologize, I'm just realizing I didn't have my mic on, so anybody else on the listening online may not have heard any of that. So just briefly, this just provides that definition of aircraft you see at the bottom of 14, lines 14 through 18 on page 2. That definition is essentially the definition that is in the rules, the Wyoming Game and Fish Commission regulations. And this comes about from the committee in the last meeting. There was some concern that the statute didn't define definitions, leaving that to Game and Fish, and so perhaps the statute should have that in there. So that's what this bill draft does, is stick that definition in there for clarity.
Questions for Mr. Hopkinson? Joint Judiciary Committee, do any of you remember why we did this? Representative Craigo?
I have a question, Madam Chairman, if that's okay. I don't have an answer to yours. Mr. Hopkinson, just a quick question. Is aircraft or any of these other words used within the definition we're adding through this bill, are those words defined elsewhere in statute?
Thank you, Madam Chair. The aircraft is defined elsewhere for other purposes in a number of different places. And it's defined differently than we've defined it here. So there are other uses of that particular term. Some of those other terms, automotive vehicle, trailer, motor propelled vehicle, are defined potentially differently in various other statutes, but it's not spelled out, and those statutes don't apply to this particular definitions that we find here.
Further questions, committee? Mr. Hopkinson, do you recall why we moved this bill draft?
Madam Chair, my recollection is that because we're using the term of aircraft here, that could potentially be unclear as to what that constitutes. There was some discussion on whether or not that decision should be made by the legislature versus Game and Fish. And so this bill draft was to come about to place that within the hands of the legislature.
Mr. Fuller?
And
Yeah, Madam Chairman, my recollection is that this bill draft was designed to make clear that included in the definition of aircraft were drones.
Representative Larson?
Madam Chairman, thank you. Are there any Game and Fish available to just ask questions to? Get into that, I guess.
There are, but not a question for Mr. Fuller or Mr. Hopkinson. So we'll go to public comment here in a minute. Representative Larson? All right, any further questions from the committee? All right, seeing none with that, we'll go to public comment. Game and Fish, please come forward. Introduce yourself to the committee. It's good to see you again.
Let me try this one. There we go. Good morning. Good morning, Senator Nethercott and members of the Judiciary Committee. My name is Rick King. I'm Chief Game Warden with the Wyoming Game and Fish Department. Appreciate the opportunity to be here today. I would just offer up that definition that is in this draft bill is exactly the same definition that we use in our rules and regulations that are promulgated by the Commission. To date, we haven't had any challenges or issues with that definition within our rules and regulations. So I think that this is potentially a good thing, but it, again, has not been an issue for us with the current definition in rules and regs. And so with that, I'll stand for any questions that you might have.
Representative Larson.
All right, thank you, Madam Chairman. Over the years, like say 5 years, have you written citations on this issue of people using aircraft to go scope or whatever, find the animals?
Senator Nethercott, Representative Larson, we have not had any citations issued for the use of drones. We've had a handful of cases of the use of aircraft, but they're pretty far and few between. Over the years, we've had a few instances. We've had a few instances of late where people have used drones to take video of wildlife and have harassed wildlife through the use of drones, but those are pretty few and far between.
Any further questions, Representative Provenza?
Thank you, Madam Chair. Mr. King, this would, I believe we allow for use of drones for shed hunting. Is that accurate?
Senator Nethercott, Representative Provenza, let's see, for shed hunting, I believe that the use of a drone would currently not be illegal to collect shed antlers. I don't know how much use is going on in the field in that regard.
Follow up? Yeah.
Yeah, so then you don't have any issues with that? We're not seeing any, say, mule deer habitat or areas being harassed during shed hunting season where wintering is an issue with wildlife?
Mr. King?
Senator Nethercott, Representative Provenza. So the state currently has a shed antler collection season that's in place, which prohibits the collection of shed antlers on public lands through the end of April. And that is designed to prevent disturbance of wintering wildlife on winter ranges. That's been an excellent tool for us to keep disturbance to wintering wildlife to a minimum. So if a person was using a drone to look for shed antlers during that time frame, they would technically be in violation of that shed antler collection season. And again, that's been highly effective at reducing disturbance on winter ranges for our big game populations.
Representative Washington.
Thank you, Madam Chair. Do your regulations presently prohibit a hunter who is otherwise lawfully shot an animal, the animal runs away, from using a drone to locate that downed animal?
Senator Nethercott, Representative Washington. Yes, that take includes everything from pulling the trigger to collecting that carcass. And so our regulations would currently prohibit the use of a drone for that.
Further follow-up? Representative, or Senator Cost?
Thank you, Madam Chair. It was my understanding that sometimes drones are being used to follow large bulls and all when they're trying to trace where they're going to drop their horns and all, and that there was a real concern about the use of drones for that. Have you heard anything about that or are aware of it, especially over in the eastern side or western side where it seems to be more predominantly hunted for sheds?
Mr. King?
Senator Nethercott, Senator Cost, I'm not aware, we're not getting a ton of reports of drone harassment of wildlife. That's not to say that it isn't occurring, but you know, our regulations do prohibit the use of aircraft, which by rules and regs includes drones, from the middle of the summer to the end of January to scout or locate or hunt, and that also prohibits disturbing wildlife. And so again, the rules are on the books to prevent that kind of activity from happening. We're not getting a ton of reports, but again, not to say that it is not occurring.
All right, final questions for Mr. King. Representative Yin.
Thank you, Madam Chairman. Mr. King, appreciate you being here. Feels kind of like TRW today instead of transportation yesterday. For these definitions of aircraft, do we have explicit statutory definitions of all the other types of vehicles that you cannot use to chase, pursue, hunt, shoot wildlife, or is aircraft the only one we're considering today? And we don't have definitions for the other ones in statute.
Mr. King?
Senator Nethercott, Representative Yin, just in 23.306, where this new definition is included, the statute reads, "No person shall harass, pursue, hunt, shoot, or kill any Wyoming wildlife except predatory animals with, from, or by the use of any aircraft, automotive vehicle, trailer, motor-propelled wheeled vehicle, or vehicle designed for travel over snow." So those specific types of vehicles are called out, but they're not further defined.
Follow up?
Madam Chairman, thank you, Mr. King. So does Game and Fish define more of those in rules and regulations?
Mr. King?
Senator Nethercott, Representative Yin, let me double check our definitions within Chapter 2 of our regulations. We do have some definitions, but I don't think we further define vehicles, but let me double check on that.
Senator Kolb, you're in the hot seat this morning.
Yeah, no kidding.
Thank you, Madam Chairman. Question, if the animal died, say you're hunting, and the animal is deceased, could you use an unmanned aircraft at that point to find it? Or anything involved with the hunt, you can't use an unmanned aircraft to use?
Senator Nethercott, Senator Kolb, that's correct. Any part of that hunt, any part of the take of that wildlife would be prohibited. The use of a drone would be prohibited.
Representative Oakley? Senator Cooper? You're the only ones I don't think that have asked a question yet. You want to just round them out? All right, any final questions? All right, seeing none. Thank you, Mr. King. Appreciate it.
Thank
Stay
you.
close. I'm sure we'll need you back. All right, further public comment? All right, seeing none.
Madam Chairman,
Mr. Fuller, yes.
do have an answer to that question about the definitions.
I knew you would.
The only other definition in their rules concerning, vehicles or the other terms that are used in 23.306 is motorized vehicle, which means any vehicle with a internal combustion or electric engine.
It's a very modern rule with an electric engine in there. All right. All right, thank you. Public comment is now closed. Committee, back to you. I need a motion on the bill. Moved by Senator moved by Senator Kolb, seconded by Senator Cost. Discussion? Seeing none, roll call vote.
Senator Cooper? Aye. Senator French excused. Senator Kolb?
Aye.
Senator Cost?
Aye.
Representative Craigo?
Aye.
Representative Larson?
Aye.
Representative Oakley?
Aye.
Representative Provenza?
Aye.
Representative Washut?
Aye.
Representative Rodriguez Williams?
Aye.
Representative Yin?
No.
Representative Zwanitzer?
Aye.
Co-Chairman Olson?
Aye.
Chairman Nethercott?
Aye.
That passes.
All right, with that, we will move to LSO Bill Draft 108, version .5, prohibiting travel across private land for hunting purposes. Mr. Hopkinson.
Thank you, Madam Chair. This bill draft comes before the committee. Previously, it had been brought before the committee based on House Bill 103. In May, the committee voted to have that turned into a committee bill draft for this meeting. What this bill does is in Wyoming statute 23305, in the game and fish statutes, under subsection B. It provides or adds the language there on line 2 that no person shall enter upon or travel through the private property of any person to hunt, fish, collect antlers, etc. And then it adds a kind of a clarifying definition of that travel through in lines 7 through 9, provides that for purposes of this subsection, travel through requires physically touching or driving on the surface of the private property. And so what this would prohibit then is an individual who is crossing private property to hunt on other property or fish, collect, etc., as so long as they are physically touching or driving on the surface of that private property when they do so. And with that, I would stand for any questions.
Thank you, Mr. Hopkinson. Questions from the committee? Representative Provenza?
Thank you, Madam Chairwoman. Just for clarification, my understanding is that in the last line, for purposes of this subsection for travel through, we make a clarification. I want to, and I think that's clear for this statute. Is there any way that this could indirectly impact any other statutes that use travel through or relate to, otherwise known as corner crossing, that this could be interpreted through courts?
Mr. Hopkinson?
Madam Chair, Representative Provenza, the language for the purposes of this subsection should restrict it specifically to this B, and so it wouldn't affect it travel through with respect to any other statute.
Representative Craigo, was House Bill 103 your bill?
Madam Chairman, yes, it was.
Do you want to remind the committee and then the public your purpose in bringing that bill and your hope for it today?
I would.
Great.
Thank you. Madam Chairman, members of the committee, House Bill 103, I originally brought that, and this is sort of a version of that with a lot less verbiage. We've simplified House Bill 103 into this particular bill draft. The purpose of the House Bill 103 and consequently this bill was to allow our game and fish officers who are in the field to actually write trespass tickets. As the law currently stands and as it's interpreted in most of our jurisdictions, people who are trespassing on private property, say out on ranch lands or fee lands out in the middle of the state, actually have to be hunting or in the act of hunting to be eligible for a ticket written by Game and Fish. The other option is a criminal trespass ticket, which requires deputies from typically our sheriff's offices to show up and write the tickets. They're usually not in the field. It's our game and fish wardens that are typically in the field during hunting season, which is when this is normally a problem. And they're just unable to deal with the problem as the statutes are currently written. This House Bill 103 and consequently this bill is an attempt to fix that, to allow our game and fish wardens to actually have the ability to write trespass tickets. And so we're doing it in the game and fish regulations because oftentimes people are driving through, they might be hunting on fee land, but they also might be driving through fee land to get to public property, whether it be state, BLM, and they're doing that to hunt on the public land, but they're ignoring the private property ownership rights to get there. And so this is just an attempt to curb that and allow our game and fish officers, who are the ones that are actually in the field, able to do something about the problem, and this gives them that authority.
Co-Chairman Olson?
Thank you, Madam Co-Chairman. Representative Craigo, I imagine what this would look like in practice with ultimately just a lot of discretion to the game and fish. My question is, if the net of the way this is drafted is too broad. I think of my friend who is a legislator who probably always has his bow ready in his pickup. And so when he drives across the land, there's no requirement that he have any intent to hunt or fish. Is that going to be enough for someone to say, oh, well, you know, you've got all the equipment, you've got your fishing gear in the back or whatever? Or is it at the point where they find them with the species that you think that's where it becomes obvious for the game and fish?
Representative Craigo?
Madam Chairman, Co-Chairman Olson, the way I envision this happening, and typically the way it does happen in the field, is Game and Fish is going to catch somebody driving back from public lands through private property with a dead animal in the back of their vehicle. At that point, they have violated this statute if we were to pass it. Before, if the person is driving through, let's say, we have friends that, we all have friends that always have a gun or a bow or something. Hopefully they're not using them out of season, which would be a big indicator they're not legally there for hunting or fishing. But just because you have that doesn't mean you're violating this statute. You may not qualify for this statute. The wardens are still going to have a lot of discretion, and they still have to prove the elements at the end of the day. Just because you're driving through private property doesn't mean you're going to be violating this bill if it were to become law. So I think you still have to remember there's a burden of proof on law enforcement, and they're not going to be writing tickets willy-nilly. This just gives them the ability, if it gives them another tool in their toolbox that they don't have right now. And they would tell you, I think, that they run into this a lot. This is not an uncommon problem. And oftentimes they get out in the field, they see somebody doing trespass, they know they're trespassing, but because it only qualifies as a criminal trespass, not a trespass to hunt, they can't write the ticket. And so they have a couple options, all of which involves getting local deputies there, which in a lot of places in Wyoming is a long drive, right? We're talking several hours to many places in rural Wyoming for a deputy to even get there. Is it when Game and Fish is sitting right there, they could write the ticket, be done. It's most likely a bondable offense, and we're done, move on, and we don't have to involve our sheriff's offices to write a criminal trespass ticket.
Representative Oakley?
Thank you, Madam Chair. I guess just to go further on that, my thoughts on it, to Representative Olson's question. I think if you do have your bow and your hunting equipment with you, and one of the elements here, of course, is you're driving across somebody's private land without their permission. So I would say probably, yes, that your friend might get cited. And to reiterate what Representative Craigo said, we still have to prove the elements beyond a reasonable doubt. But I think hunting equipment could very well then be inferred that that's what you're doing. That would be, of course, Game and Fish would have to determine that, and then it would go to the county attorney's office and they would have to agree. But yes, that's where we're getting, is if people are going to be trespassing on private land with all the trappings of that they're doing it to hunt or fish, that's what this is going to hit. So I guess my thought is, like you're saying, you've got a friend who's always got his bow, but he shouldn't be trespassing on people's land. So
Criminal trespass.
right. Exactly. He could be, but I think if you've got the hunting equipment and you're trespassing on somebody's land, yeah, I think you could expect for this to come into play.
But good news, fortunately, your friend has fancy GPS equipment, so he would not do that. All right, Representative Washit?
Thank you, Madam Chair. Listening to Representative Craigo's description of someone who's already completed a hunt and is now returning across private land made me think about the word to, travel through to hunt. The hunt's been completed. Now the individual's returning from the hunt. Does that word travel through to hunt is it broad enough to include the return trip?
Mr. Hopkinson?
Madam Chair, to answer that question, I do think there could be a potential issue there, because I think that too would indicate that you're traveling to that land, not returning from. The act is completed, and it seems to me like there would be a challenge there, even having evidence that this hunt occurred, that they're now on this land, to say that they were before the hunt. I don't know that you could do that. So the way it's currently written, it could be challenging to say that this would apply to someone returning from a completed hunt.
Who wrote this?
Senator Cooper.
Thank you, Madam Chairman. I really don't care if he's going to or from. If he's traveling across my land, he's trespassing. My question here is the language on travel through is uncomfortably close to the language on the sections we repealed on that earlier bill. Is there anything here that is going to wind up being unconstitutional, similar to what that one was, or are we okay to move forward with this?
Mr. Hopkinson, are you concerned about the constitutionality of this bill draft?
Madam Chair, there are some important distinctions with this versus what was repealed. That was specifically dealing with speech issues, the crossing public or private property to collect data, and was deemed a violation of the First Amendment. When we're talking about hunting, fishing, that sort of thing, I'm not sure that we see those same issues there. But I could certainly, and I would be happy to dive into that more deeply and provide a more coherent answer. But on the surface, I don't see those same issues being applicable in this particular case.
Co-Chairman Olson?
Thank you, Madam Co-Chairman. Representative Crago, one thing that I notice is obviously different in this draft from your original bill is the forfeiture provision. Is that necessary to exist in this bill, or will Game and Fish have the proper authority that they need if they do cite someone and they do find them with an animal, that they can confiscate the animal?
Representative Grego?
Madam Chairman, Co-Chairman Olson, that would be a good question for our Game and Fish fella sitting in the audience, because I'm not sure, it's a little unclear how that would apply to this particular bill in my mind, but I guess I would love to hear from the agency.
Let's hold that question. Mr. King, why don't you think about it? And when we bring you back up, be prepared to answer that. Representative Yin?
Madam Chairman, thank you. And maybe this is a question for Representative Crago. I'm curious on why the attempt to, if the intent is to give game and fish wardens the ability to cite trespassing, why would we not just put that ability in the definition of them in peace officers or in the criminal trespass statute to allow them that enforcement capability for trespassing, rather than create a second new penalty for trespassing when it comes to hunting?
Come forward, Mr. King. So, Mr. King, if you would please reintroduce yourself to the committee, your name and who you're with.
Madam Chair, members of the committee, my name is Rick King, Chief Game Warden with the Wyoming Game and Fish Department.
All right. We'll start with Representative Yin's question. Representative Yin, can you repeat your question?
Mr. Chairman, Madam Chairman, thank you. So the question is essentially, what is the benefit of having this in the game and fish statutes versus having the ability for game and fish wardens to do this in the criminal procedure statutes?
Mr. King.
Madam Chair, Representative Yin, I'll start with just giving some background information. So Wyoming Game and Fish officers have a unique peace officer status that's spelled out in statutes. Within that, we, for the most part, do not enforce Title VI, criminal trespass. But of course, we do enforce trespass under Title 23. Trespassing is a very common violation. Usually it's the second most common violation that our officers deal with each year. We deal with it hundreds of times each year. It's a very common violation. Usually it's number 2 in our top 10 most common violations. And for the most part, a lot of those trespass violations are fairly cut and dry and pretty easy to deal with, but there's always some unique circumstances that have to be evaluated on a case-by-case basis. And I think the intent of this was to clarify one of those unique circumstances where under Title 23, we have to prove the intent and the act of actually hunting on private property in order to cite them. Otherwise, if a person is just on private property, but they're not in the act of hunting and we can't show or prove that, then it would fall under criminal trespass, which would require a deputy to come out and issue a citation for criminal trespass under Title VI. So I think the intent of this was that if our wardens come across somebody that's traveling through private property to or from a private property to hunt somewhere, that then we would have the authority to deal with that as a Title 23 trespass. Our officers are still going to be required to show intent and prove intent. They're still going to have to prove that there was hunting activity that occurred after trespass through private property. So there's still a significant burden of proof for our wardens to demonstrate before a citation could be issued under this draft language. Does that answer your question?
Mr. King, I just kind of follow up. Can you explain maybe the policy as to why you're not authorized to enforce Title VI, which is the criminal code?
Sure, Madam Chair, members of the committee. So Wyoming's peace officer definition is unique, and game wardens are spelled out in Title VII with a unique peace officer definition, so that our peace officer authority is limited by statute and very specific to certain components of statutes that we can enforce. And Title VI is generally not included in that, except when we're requested to assist other agencies.
Senator Cooper, Senator Kolb, then Representative Washit.
Thank you, Madam Chair. Yeah, years ago, a lot of our game wardens were deputized. Is that something that's still available as a tool for enforcement in the field?
Mr. King?
Madam Chair, Senator Cooper, you are correct. It's been a long time since our wardens have been deputized under a county sheriff's office. We currently are not. I don't think there's anything that would prohibit us from doing that, but it's been quite a while. In my career, we have not been deputized under a county sheriff's office.
Senator Kolb?
Thank you, Madam Chair. Mr. King, is there a duty that a hunter has to know that he's on private property and without being posted? Just an open question. Thank you.
Mr. King?
Madam Chair, Senator Kolb, that's a good question. In Wyoming, it is the hunter's responsibility to know whose property they're on, and that property, for the purposes of Title 23, trespassing to hunt or fish, does not require the landowner to inform a hunter that they're on private property. It is the hunter's burden to know whose property they're on.
Representative Washit?
Thank you, Madam Chair. If we were to take Representative Yin's suggestion and put this in your statutory authority, that would also involve giving wardens authority to enforce criminal trespass in non-hunting fishing circumstances. Is that correct? Would that be something that would be desirable by the Game and Fish?
I don't think that's Representative Yin's suggestion, but Mr. King?
Madam Chair, Representative Washit. So I think that Certainly, our game and fish officers are extremely busy and have full workloads just dealing with the statutory authorities that we do have, in addition to the myriad of other duties that game wardens are responsible for in the realm of wildlife management. So I think that, to answer your question, I think that expanding that peace officer definition to address trespassing, my suggestion would be, if that's the route, the desire of the committee or the legislature, that it be very specific for criminal trespass and not expand that peace officer authority more broadly. I think that would create a significant burden on our agency in terms of workloads and responsibilities.
Representative Larson.
Madam Chairman, thank you. I guess the question I would have is, do you think we'd need to clearly post? The landowner would have to notify that hunter or fisherman that they are trespassing. I guess that's where I'm kind of having an issue with is, are we still going to have that clearly posted?
Mr. King.
Madam Chair, Representative Larson, so again, under Title 23, a landowner doesn't have that responsibility to post their private property. But under Title 6, criminal trespass, a landowner does have to provide notice to a person that they're trespassing. And so that can be either telling them they're on private property and asking them to leave, or posting the property. So if we were to enforce criminal trespass, then that property, that person would have to be notified, just as it is in Title 6 right now.
Representative Yin.
So, thank you, Madam Chairman. Mr. King, so then if we pass the bill as drafted, would we be having a lower burden of proof for citation for the traveled through language versus criminal trespassing, where the law enforcement, the game warden, isn't required to prove that it's actually trespassing from the private property owner?
Mr. Hopkinson. Representative Yin, can you repeat the question?
Madam Chairman, is the burden of proof lower in the bill draft than criminal trespassing?
And that's a legal question, so I'm directing that to our LSO staff.
Madam Chair, specifically that term burden of proof would still be proof beyond a reasonable doubt, regardless of whether it's the regular criminal trespass or this trespass.
Representative Oakley.
Thank you, Madam Chair. So what we're looking at is basically two different forms of trespass. They have different elements. It's not a different burden. So what he said was absolutely correct. Our Title VI has, you're upon the land of somebody else, and there's two different ways, which is you've been told to leave, or what was the other one? You said it, but, or it's posted, and then you're on there. So then those elements have to be met. This one, we're putting specifically, of course, in the game and fish statutes, and has the extra element of what I consider trespass. You're already trespassing on somebody's land, at least as we kind of use it in Wyoming, because you're supposed to know that you're not, that you're on somebody's land. But so in that way, you're already, the wording is, on their land without their permission. And then this has the extra element of to hunt, fish, or do whatever. So it doesn't change burdens. It'll never change burdens. It's always beyond a reasonable doubt. Different elements. This one's specific to hunting and fishing.
Follow-up, Representative Yin.
Thank you, Madam Chairman. I think this is a situation where it becomes apparent that I'm not a lawyer. So I guess my concern is essentially similar, I think, to Representative Larson's concern is, how does a game warden know that a person is trespassing if they are not sure that the private property owner has not granted that person permission to travel through the private property?
Mr. King, how do you investigate that crime?
Madam Chair, Representative Yin, yeah, that's a great question. And again, our officers, whenever they respond to a trespass complaint, have to do just that. They have to determine, what was the person doing? Do they have permission or not? A hunter is required to have signed permission from a landowner to be on private property. So that's one easy way to determine if they did have permission, is if they have a proof from a landowner that they were allowed to be there, but that may not always be the case. It could be a verbal handshake agreement. So as Representative Oakley mentioned, there are a lot of elements to prove in a trespass case that our wardens have to step through as they respond to each of those complaints.
Representative Provenza.
Thank you, Madam Chairwoman. I guess when we're talking about burden, the difference between, not necessarily burden of proof, but the burden to know that element is on the hunter, right? And so if the hunter has to know exactly if they're on private property or not, versus if they're seen potentially as a hiker or a pedestrian who's not trying to hunt, then the burden is at least somewhat on the landlord. And so does that burden, not burden of proof, but burden on the person potentially trespassing, change if they are with a firearm? I know you mentioned the element of having to prove that they had that intent of going to hunt, but my concern is that we have a huge proportion of Wyoming, myself included, with angling equipment or guns in our vehicles, potentially able to hunt at any moment. So does that burden in that sense change?
Mr. King, again, to how you investigate the crime of trespass. And in this case, this does not apply to hikers, right? This applies to people who are trespassing for the purposes of hunting, fishing, collecting antlers or horns. And so how do you investigate the purpose as to why they are on that land, if you can?
Yeah, Madam Chair. So again, I think that, of course, just simply talking to the person that's on the private property, that's probably the most common technique we would use to determine what they're actually doing and whether or not they're violating this statute or Title VI. And so just a conversation, it could be observation of their activity. It could be the equipment that they have. It could be a combination of all those things. And again, our officers in the field have to collect all that information and then make a determination as to whether that person was actually trespassing to hunt, fish, trap, or collect antlers, or if they were just simply on that private property for other purposes. So.
And Mr. King, tell us what happens when a landowner calls to report someone on their land and they're just hiking. What happens?
Yeah, Madam Chair. So, in that hypothetical situation, if our officers responded to a trespass complaint and determined that a person wasn't actually trespassing to hunt, fish, trap, or collect antlers, and they were just simply trespassing on that private property, then it would fall to a Title VI trespass situation. And in that case, we'd continue to gather up information, but at that point, it would have to be turned over to the sheriff's office to handle as a Title VI trespass.
Representative Oakley?
Thank you, Madam Chair. So, we've been talking about it. A lot of these questions just come down to what is done in literally every case that any law enforcement might deal with, which is evidence collection, investigation, things like that. So what I'm hearing, which is, it's good thought, we've got defense attorneys here on the panel evidently. If you weren't there to hunt, that's an element, that's a defense. That's what, again, this could be done in any case. If you had permission, let's say you asked and you said, do you have, and the warden asked and they said, well, I had permission. And they're like, well, interesting, because the landowner called me and said you didn't. Then they find out he did. That's a defense. Then it's dismissed. This is what's done in every criminal case, and wardens don't want to, and our law enforcement don't want to try to cite people who are guilty. When there's a legitimate defense, that cases are dismissed. That's what happens. Or in this case, if they knew they had permission, they wouldn't cite it because it's not a violation of this. That doesn't mean that the statute and what you're trying to get at isn't legitimate because somebody might have a defense. If they have a defense, they won't be convicted of it. So good thoughts, but every element has to be proved beyond a reasonable doubt and would be found by the wardens, hopefully before their citing and certainly when it's followed up at the courts. So good ideas for defenses, but not necessarily relevant to passing the statute.
Mr. King, Co-Chairman Olson had asked about the forfeiture provision, and do you recall that question?
Sure.
Yeah, can you answer that now?
Yeah, Madam Chair, Representative Olson. So our wardens do have the ability to seize any evidence of a crime. So if a person harvested an animal as a result of trespassing, that animal could be seized and held. And then the court could determine that the outcome of any of that evidence that's seized, which could include the court ordering the forfeiture of that animal. So I know the draft version that came about in the last legislative session had some specific penalty portions. I don't believe those would be necessary for us to seize an animal and then have a court order that to be forfeited.
All right, final questions right now from Mr. King before we go to further public comment. All right, Mr. King, thank you so much. Stay close. You will be back, I have no doubt.
Thank you.
Senator Bill Landon, Natrona County's own, is here joining us today. Good to see you, Senator Landon, here, back of the room. All right, with further public comment on this bill, Mr. Magagna?
Thank you, Madam Chair. Jim McGagnon with the Wyoming Stock Growers Association. And we see a real need for this bill. We certainly are supportive of it. A scenario that I'm aware of, at least in some instances that perhaps wasn't mentioned here earlier, is where someone illegally under the current law kills an animal on private land. But then when they're stopped by a game warden or anyone else, they say, oh, I killed it over there on the public land. I'm just traveling across here to return home with it or something. So this provides some protection in that scenario as well, which we think is important. Do have a bit of concern. Well, I understand the reason perhaps as a practical matter for including the provision on lines 7 through 9 about physically touching or driving on the surface. The question I anticipate that I will certainly get from landowners is, if you look at Title 10 of the Wyoming statutes, which the aeronautics, it makes it clear without any limitations, as I read it, that the landowner owns the space above their land. So the question I anticipate here then, well, why are we in this case only protecting a part of the landowner's property right rather than the entire property right? And I don't know that I have an answer to that I would be able to provide. Would be interested if there's any thought about that by members of the committee or.
Committee members, this issue is currently in litigation. I urge caution. Representative Oakley.
Thank you, Madam Chair. Mr. Magagna, do you see, I mean, since what we're trying to get at is when they're going to hunt, do you see with your scenario a way that landowners would be saying you missed the mark with what we're trying to do here with the language that we currently have?
Mr. Magagna?
Madam Chair, Representative Oakley, I don't believe that that's the case. What I see is that there's simply a question landowners are going to have. The other component of that I might mention, putting aside the current litigation that's in federal court that is a matter of what the federal law requires, but setting that aside, looking at this just from a state perspective. The other thought is perhaps not legally that I can see, but at least in the court of public opinion, will seeing this language be used as further evidence that the state really does not support protecting the landowner's right to that reasonable amount of space above their property. I think it raises some of those issues. Perhaps we just have to deal with those, but I do believe we should be aware of them.
Thank you, Mr. Magagna. Is that issue addressed in any other area of statute, such as the one we already passed this morning, where we codified aircraft in the game and fish statutes from their rules and regs that would address the concerns of protecting private property owners' rights to the airspace above their property? I don't know the answer to that. I'll give you a minute to find it or think about it. Questions of Mr. Magagna as that question's being answered? Senator Cost?
Thank you, Madam Chair, and it might go to you, but right now it's really more concerned with hunting than it is with, without hunting than rather hunting. Drones flying over electrical lines, pipelines, that kind of thing, check flags that from our service areas. Our crop sprayers and that coming down into that airspace to be able to spray a field if somebody else is right beside theirs or whatever. Does that become an issue now as well?
Madam Chair, Senator Cost, I think there's been a practical approach to that. I raised the issue because as I read Title 10 with dealing with aircraft, which we're not talking about here, but there's no language in there that I've seen that intends to limit that grant the control of airspace just to Title 10. It seems we've looked at it as potentially a broad statement that the state recognizes the right to protection of some reasonable airspace above your private property. So I raise it in that context, even though this particular law is certainly not dealing with the use of aircraft. That's dealt with separately.
Further questions of Mr. Magagna? All right, seeing none. Thank you. Thank you for your comments.
Thank you, Madam Chair.
Further public comment? Mr. Novotny, welcome. Anyone need some coffee? Welcome, please introduce yourself.
Good morning, Madam Chair, members of the committee. Bill Novotny with the Wyoming Outfitters and Guides Association, and we share the support of the stock growers in the concept behind this, and certainly we were very supportive of the work that Representative Craigo put forth early on in this area. We think this is a good compromise that is workable. Certainly in our portion of the state, one of the problems that we see very frequently is predominantly out-of-state hunters who like to park in the interstate right-of-way, cross private lands to access blocks of public lands. And we've been told by YDOT that they have no interest in enforcing that. Certainly, in my other hat, our county sheriff's offices don't have the resources to deal with that. You already have game and fish individuals out in the field dealing with other violations or just work protecting the resource. And we think this is a good workable new tool that our game and fish law enforcement personnel should have. And we are in full support of seeing this passed and put into statute. Thank you.
Questions for Mr. Novotny? All right, seeing none, thank you for your comments. Further public comment on this bill?
Madam Chairman, I think there might be a person online.
We'll get to that. Any further public comments in the room? All right, seeing none. Let's go to online.
Madam Chair, we have Brett Moline from the Wyoming Farm Bureau.
Let's let him in. Mr. Moline, please introduce yourself to the committee and share with us your comments.
Thank you, Madam Chairman. Brett Moline, Wyoming Farm Bureau Federation. I hope I'm not coming across too loud.
You're fine.
Okay, thank you, ma'am. I'm sitting in support of this bill. This is an important issue that is facing my members across the state, and sitting in support of it. Perhaps this would be a very simple fix for the concern raised by Mr. Magagna, but on page 2, line 9, where it says driving on the surface of the private property, if we just took on the surface out, so it would read driving on, touching or driving on the private property. That may be a simple fix to alleviate that concern of Mr. McGagnis. With that, Madam Chairwoman, I would sit for any questions you or the committee may have.
Questions for Mr. Moline? All right, seeing none. Further public comment? I would certainly love to hear from public comment rather than reading about the criticisms in some newspaper article. It'd be really helpful to hear those concerns now for the committee so we can consider them instead of reading about them later. All right. With that, public comment is closed. Committee, back to you.
Move the bill.
Moved by Co-Chairman Olson, seconded by Senator Cost. Discussion. Bring the committee's attention back to the concern presented by Representative Washut. Representative Washut, do you have a solution to your concern?
Thank you, Madam Chair. I don't have specific language. I think I'll need some wordsmithing probably from the LSO attorneys, but the intent would be of my motion to amend that we massage the language on lines 2 through 5 to include returning from a hunting or fishing, trapping, horn gathering expedition.
We're just going to take a moment. I think that we can actually come up with the language here now. Representative Yan, you have some thoughts?
Madam Chairman, my concern was, I wanted to clarify what my concern was, which is separate from what Representative Washut's dealing with. So if we want to deal with that first before I.
Let's do that. Yeah. Representative Oakley, Craigo? Representative Oakley?
Thank you, Madam Chair. I'm trying to find, the word take is defined in game and fish statutes. I want to find that. I'm thinking it may be helpful. It's got a very broad definition. Let me find that, but I think that might be help to be included.
Yeah. Madam Chairman, Representative Oakley, take is defined in the general definitions of the game and fish title. It's 23.1.102A7. And take means hunt, pursue, catch, capture, shoot, fish, sign, trap, kill, or possess, or attempt to hunt, pursue, catch, capture, shoot, fish, sign, trap, kill, or possess.
So one idea, not completely finished, for purposes related to taking, comma, hunt, fish, collect antlers. For purposes, so removing the word to and say, the private property of any person for the purposes related to, and then hunting, fishing, collecting antlers. It's a really good talk we're having. Representative Washut?
My only concern there would be, going onto someone's land to reach the landowner and ask permission might be related to hunting, but it's not something we want to prohibit. That they're entering onto the property without permission, but the purpose is to contact the landowner and seek permission, not to actually take. So I think related to might be too broad.
That's my motion. Is there a second?
Second.
Seconded by Co-Chairman Olson. Further discussion on that motion? Representative Grego?
Madam Chairman, would you repeat your motion, please? I apologize.
So the statutory section would read, no person shall enter upon or travel through the private property of any person for the purposes related to taking, hunting, fishing, collecting antlers or horns, or trapping without the permission of the owner or person in charge of the property. Representative Grego.
Madam Chairman, just a question, I guess, for you and maybe this for our good attorneys. I'm curious why the word take was never included with this statute to begin with. Because it's included in all the other game and fish statutes, violations, et cetera. The word take is usually the
we-
first word. And so I'm just,
Blame the legislature?
Yeah.
This is how that happens. Mr. King, do you know the historical answer to that as to why taking is omitted from the statutory provision? LSO, do you have any thoughts about that? When was the statute originally created? And can you see when taking was placed into definitions? No doubt the Ag Committee. Representative Grego.
Madam Chairman, while our lawyers are looking that up, I guess here's my comment on any amendments that we're going to make to this bill is I don't want to complicate it to the point where we risk passage of the bill, even if it's to make, I guess I'd rather have it 90% perfect than 100% perfect and pass it and at least give our game wardens the ability to do what they need to do. Because if we start monkeying with the language, we're going to open a whole bunch of other doors that I was never intending to open to begin with my first bill, and I'm not sure we want to do that as a committee. That's my only comment is, and I understand Representative Washett's concern. I agree. I see what he's saying. I'm not sure. I still think we could write the ticket, even if they're coming back. I'm not terribly concerned about that. But if we could find some language that would cover that, fine. I don't want to cast too wide of a net to make that one change.
Representative Grego will be voting no. Another alternative would be, if the committee's desire, which after we make a motion, after we vote on this motion, is to ask to have this bill on our agenda at the third meeting to allow for further public comment and review of the final bill for better thoughts, right? If the committee would like to continue to work it, I think that's prudent. Representative Oakley?
Thank you, Madam Chair. I don't know if it's perfect, but I think it's fine. I don't think your addition of for the purposes related to taking hunting somehow confuses the point of the bill. I don't see how that's done. So again, maybe we can tweak it, but I personally don't see a problem with the sort of the bit of tweaking and broadening that you've done.
Mr. Fuller, do you have some brilliant thoughts?
Madam Chairman, I have just thoughts.
The chairman says they're brilliant.
Much appreciated. Madam Chairman, that subsection B, and this is only as far as I can go back, was amended in 1991. I can't tell what was changed in that subsection. The word take, though, was not included in that version of the bill. So that exclusion has been in statute for at least 30 years. In terms of when the definition of take was included, I haven't gone through all of those bills that I'm able to yet. I would assume, given some of the language in that definition, though, some of the terms that are used, that the definition has been around for a while.
Co-Chairman Olson?
Yeah, Madam Co-Chairman, just to maybe put some of Representative Crego's concerns at ease with this amendment, 90% of the attorneys in the House are sitting on this committee right now. So I think in terms of getting into the deep weeds of a legal discussion, if it comes out of this committee with the support, I don't see that. I think in the House, you're going to have policy arguments more about between hunters and landowners than you are between the deep legal. I think that if we're comfortable with it, we should get it right here. So I think this amendment, I agree with Co-Chairman Nethercott. I would like to have another meeting to mull it over and see, so we can go back through it and make sure it's the way we want it. But I'd rather not be ambiguous, and the fact that the existing statute for 30 years is missing the word that we believe should be there taking. I'd rather this committee do good work and frankly, clean that up. If it's supposed to be there, then why not? If you think it's in 80% of all the other statutes in this area, then why, we ought to clean that up while we're here too, in my opinion. Thank you, Madam Co-Chairman.
Question on the motion. All those in favor of the motion, please say aye.
Aye.
All those opposed say no. That motion has failed. Representative Yen?
Madam Chairman, thank you. So just to clarify my concern, I think so ultimately my concern is that the definition of criminal trespass is different than the definition of the prohibition of entering another person's property in Title 23. So criminal trespass requires that the person's guilty if they know that they're not authorized to do so, or after being notified to depart or not trespass, and notice is given by either personal communication or a posting of sign. In the Title 23 version that we are in this bill granting to game wardens, those requirements are not there. So they just have to have permission to be there, rather than not know that they don't have permission to be there. So I do think that game wardens would be able to, with this bill, cite tickets that peace officers would not be able to cite for criminal trespass. And that's ultimately my concern, which is something that where if we just allowed game wardens or had the same exact definition, probably be more comfortable with. But I think this definition is now more expansive than it is in criminal trespass. Thank you, Madam Chairman.
For purposes of education and information, Mr. King, please come forward. And of course, this is the Judiciary Committee. But Mr. King, if you can briefly provide a generalized overview of the difference associated with your statutes and the privileges and education requirements associated with hunters, as to why the definitions for trespass may be different as opposed to me trespassing on my neighbor's land in urban Casper, for example.
There we go. Madam Chair, to answer your question, I think that, as you all know, hunting is a privilege and in the state, and hunters have a lot of responsibilities that they need to meet in order to participate in hunting activity, including things like taking a hunter education course, and which covers firearm safety and ethics, et cetera. And I think that the Title 23 trespass to hunt and fish and trap has been on the books for a long time. And I think that it's always been an assumed responsibility of a hunter that they need to know whose property they're on, in addition to the other rules and regulations and statutes that they are agreeing to follow when they're participating in hunting, fishing, or trapping activity. So I'm not sure if I'm answering your question, but that difference that exists between Title 23 trespass to hunt and Title 6 criminal trespass has been around for quite a while. And I would just offer up that from my perspective, hunters do have sort of enhanced responsibilities that come along with participating in hunting and fishing, and knowing whose property they're on, and ensuring that they have explicit permission to be there has always been one of those assumed responsibilities. Does that answer your question?
Yes, thanks. Representative Larson.
Madam Chairman, I'd like to make two amendments separate.
Okay.
Go ahead. Okay. First amendment, maybe to simplify what you would propose to insert after person when in the process, and after the word to, put take and a comma. That's my first amendment.
Okay, moved by Representative Larson, seconded by Representative Olson. Representative Larson, would you repeat that so everyone understands and can track?
Okay, I'll just read the sentence. No person shall enter upon or travel through the private property of any person when in the process to take, hunt, fish, collect antlers or horns, or trap without permission.
Representative Washut, does that address your concern? It's still prospective as opposed to,
Generally, yes. I think that the process of coming to and from, I think process takes that in. I'm not sure that inserting the word take what?
well, that's the definition that we discussed, Representative Washut, that's found in statute in the definitions under the hunting. Representative Craigo?
Thank you, Madam Chairman. I guess what I would say, if I'm allowed to do so at this point, discussion on the amendment, that particular amendment essentially undoes what the entire purpose of the bill is supposed to do, which is right now, as it's written, the statute requires you to be in the process of doing something on private property. What the bill draft is attempting to do is also cover the circumstance where you're not necessarily hunting on private property, but you're driving through private property to get to public property, or vice versa, coming back from public property to drive through private property. And so I think that particular amendment just takes us back to where we were to begin with the original language of the statute. So I would not be supportive of the amendment. I know what you're trying, I know what Representative Larson is trying to do, Madam Chairman, but I think that it's not, that particular language will take us backwards.
I think you clearly just don't want to amend this.
Further discussion on the motion? Representative Larson?
Madam Chairman, thank you. The definition of process is a series or action steps taken in order to achieve a particular end. And I think if you're hunting generally, I think that process would describe passing through.
Question having been called, all those in favor say aye. Aye. All those opposed say no. No. That motion has failed. Representative Larson, you have a second motion?
Madam Chairman, yes, I'd like to take the issue that the stock growers brought up, and I would like to delete everything that was inserted on line 7 through 9.
Is there a second? All right, that has failed for lack of a second. Further discussion on the bill? Representative Washut?
It'd be my preference that we schedule the bill for further discussion at our third meeting, and that between now and then, we can work on some potential language to deal with the returning hunter, as opposed to making any decisions on the further amendments today.
Senator Kolb?
Thank you, Madam Chair. I look at this as, do we have a good bill and we throw it out because we're in pursuit of the perfect? I think that's a fool's errand. I think there's a lot of things that we've discussed that we just can't deal with. We can't deal with the airspace right now. It's in court. And that doesn't mean that personally I don't care about property owners. I do. But there's certain things that we can do, and I think this bill maybe needs a little tweaking. Maybe that's true. But I think perfection is just not going to be obtained by people. But it's a good bill, and it serves a good purpose, and it improves the situation. Thank you, Madam Chair.
Further discussion?
Madam Chair.
Representative Rodriguez-Williams?
Thank you, Madam Chair. I agree with the good Vice Chair and postponing the bill and continuing to work it. And furthermore, I think I'd like to hear testimony from the Sheriff's Association, their perspective, and potentially hunters organizations as well.
Senator Cooper?
Thank you, Madam Chair. I think this bill, as it stands, is very clear, and it accomplishes the purpose we're trying to do. The problems we have on my land are not the deer hunter or the elk hunter. It's the cat hunters, the horn hunters that are there at different seasons than the general hunters. The general hunters are fine. I don't have a problem with them. In fact, we have a walk-in area. I give them public access. But that public access does not include horn hunting and doesn't include cat hunting. The horn hunting happens in the spring when the ground is wet, and the damage they do just driving across it is unbelievable. They leave ruts a foot, 2 foot deep. You know, they tear up the roads. After they get the road tore up, they drive around the hole. The damage done traveling through the land is, especially in the horn hunting season, is far worse than just somebody getting out and walking across. I think this does exactly what we need to do. It gives the landowner the help he needs to control it, and I think we need to move this bill forward.
Further discussion? I'm going to turn Representative Washat's comments into a motion that the committee postpone it to the third meeting, which is seconded by Representative Rodriguez-Williams. Everyone's all right with that, I assume? All those in favor of putting it on the next meeting, please say aye. Aye. All those opposed say no. No. All right, that motion has passed. All right, so this bill will be on our meeting. I expect the committee, Representative Washat, to come back with language to address your concerns that have been identified and supported by Mr. Hopkinson, as found with it being a prospective concern, and to be ready to work this bill to have all those concerns identified. Mr. King, if you also can be prepared to provide a presentation, perhaps with the sheriffs and chiefs, really educating the committee on the differences and distinctions between general law enforcement duties, game and fish wardens' duties, and why there's different statutes and criminal laws for those two different purposes and jurisdictions. Okay.
Madam Chair, I'd be happy to do that. Thank you.
Thank you, Co-Chairman Olson.
Yeah, just real quick, I think it would also be helpful to bring forward some concrete examples of, I mean, I obviously know I've talked with Representative Crago early in the session, so I know there are, this is an issue, but I think some concrete examples of that you've had where you couldn't do what you needed to do, not anecdotally or hypothetically, just some real scenarios where we ran into some issues that, as factual as we can, then I think it helps us understand that the language, right? Whether it's fine based on the scenarios that you present to us.
All right, thank you. With that, committee, we will lay 108 back to our third meeting, and we'll take a 5-minute break coming back at, or 7-minute break coming back at 10:05 to move on to 10, just a quick mid-morning break. That's the wrong bill. All right, committee, we are coming back together. Are we live? Wonderful, we are live. We're coming back together at 10:06. We are on LSO Bill Draft 110, prohibiting drones over penal institutions. Mr. Hopkinson?
Thank you, Madam Chair. David Hopkinson with the Legislative Service Office, reviewing prohibiting drones over penal institutions, 23 LSO 110, working draft 0.4. This bill draft comes as a result of a lot of discussion that the committee had at the last meeting. There, frankly, are a lot of policy decisions that were made in the process of creating this bill draft that are certainly for the committee to ratify or alter as they see fit. So I'll walk through and talk about what this bill does. The first section on page 2 provides some definitions. I want to highlight the unmanned aircraft definition because that is very important to what this bill covers. And that provides that an unmanned aircraft system is an unmanned powered aircraft that does not carry a human operator, can be autonomous or remotely piloted or operated, and can be expendable or recoverable. On page 3, we talk about specifically what it is not. And these are some important exclusions. It does not include a satellite orbiting the Earth, an unmanned aircraft system used by the United States government, or someone acting pursuant to contract with the United States government. It does not include a system used by the state for purposes of state business. And it does not include one used by law enforcement, emergency medical services, hazard materials response team, disaster management, or other emergency management agencies when and for the purposes of incident command, area reconnaissance personnel, etc. We start getting into the meat of the bill here in subsection B at the bottom of page 3 that provides that except as authorized by a person in charge of the penal institution or correctional facility. And I want to pause for just one moment and highlight that this bill does cover with the penal institutions or correctional facility, that language does include county jails. And so that, again, policy question for the committee to look at if they want to, how far they want that to extend. But as drafted, it would include county jails. It provides that no person shall intentionally, moving on to page 4, photograph, surveil, broadcast, or otherwise record a penal institution through the use or correctional facility through the use of an unmanned aircraft system, that they convey or attempt to convey contraband to a person confined in a penal institution or correctional facility through the use of an unmanned aircraft system, or that they deliver or attempt to deliver a deadly weapon into a penal institution or correctional facility through the use of an unmanned aircraft system. So those are the 3 core prohibitions that this bill makes. Paragraph 2 and 3 there, the convey to or attempt to convey contraband or the deliver or attempt to deliver a deadly weapon, those, the language used there is the same as what we see in existing statute, just with the added use of an unmanned aircraft system. The punishment for those offenses is in subsection C, that any person who violates B1 or 2 is guilty of a misdemeanor, punishable by imprisonment for not more than 1 year, fine of not more than $2,000 or both. And that punishment is in line specifically with the second paragraph of existing punishment for conveying or attempt to convey contraband. And then any person who violates paragraph B3 is guilty of a felony, punishable by imprisonment for not more than 10 years, a fine of not more than $10,000 or both. And again, that's consistent with the offense of delivering or attempting to deliver a deadly weapon without using a drone. Subsection C provides kind of a notice requirement that a person who uses an unmanned aircraft system under one or more of the exclusions specified previously. So we're looking back then at what it does not. Apologize, I've lost my place here. You're looking at the United States government, state purposes for state businesses, those exclusions there. that anyone using it for those purposes would need to provide notice, reasonable notice of the intended use of that unmanned aircraft system to the penal institution or correctional facility, to that person in charge of that institution or facility. And then subsection C provides, or E, excuse me, on page 5, that the person in charge of that penal institution or correctional facility may take or authorize the use of reasonable actions to prevent or stop the use of unmanned aircraft systems operating in violation of the sections that we previously looked at, consistent with rules and regulations promulgated by the Department of Corrections. And so this, and we see the addition of language on page 7, new language that would require the Department of Corrections to promulgate rules and regulations specifying what actions can be taken by the person in charge of a correctional facility or penal institution to stop or prevent violations of this act. The staff comment just includes some of the statutes that have been pulled from and some of those definitions that are referenced. It provides the definition there of contraband and some of those other offenses that I previously mentioned that this draft pulls from. Section 3, the staff comment on page 7 just notes that the rulemaking, the way that works with the Department of Corrections can be different than you see with other agencies, and that's just noted there in that staff comment. Section 3 requires the department to promulgate rules necessary for this act. And then section 4 provides a split effective date that would require by July 1st, 2023, that the department have promulgated the rules necessary, and the act would be effective on that date. With that, I would stand for any questions on this draft.
Rodriguez-Williams?
Thank you, Madam Chair. Question for Mr. Hopkinson. I'm just curious, I see that the word contraband is defined in statute, but I'm curious if deadly weapon is defined or if there's a need to insert that in definitions.
Mr. Hopkinson, if you know?
Madam Chair, deadly weapon is defined in statute, and I can pull that up. Do you have it already? Oh, Brian, Mr. Fuller has that.
Mr. Fuller?
Madam Chairman, Representative Rodriguez-Williams, this is 61104A4. Deadly weapon means, but is not limited to, a firearm, explosive or incendiary material, motorized vehicle, an animal or other device, instrument, material, or substance, which in the manner it is used or intended to be used is reasonably capable of producing death or serious bodily injury.
Representative Provenza?
Thank you, Madam Chairwoman. On page 4, in that enumerate I, the photograph, surveil, broadcast, or otherwise record a penal institution or correctional facility through the use of an unmanned aircraft system. If I am flying a drone or unmanned aircraft system near Department of Corrections property, but I am not on or above a correctional facility, and I'm photographing or I get footage of a correctional facility, am I in violation of this statute?
Mr. Hopkinson, what is the intent required?
Madam Chair, this, as drafted, there really isn't an intent specified in this bill draft. So potentially, if you were there photographing or surveilling it.
Mr. Hopkinson, I think you emphasized when you read the bill draft intentionally. So in my interpretation, it has a specific intent requirement in the bill draft to surveil, photograph the penal institution. So if you are up in the sky and you happen to do it, I'm not sure that could be, that a conviction would result from that or a prosecution would result from that. Would you agree?
That I would agree with that.
Representative Provenza?
Thank you, Madam Chairwoman. And so my understanding of this intentionally is that you might be intentionally photographing or filming that facility, but without the intent of trying to drop contraband or have a special view of the facility to then draft plans for escape or anything like that. You may intentionally photograph it. May have intended to get a photograph of Department of Corrections without ill intent. Is that going to be a potential First Amendment issue with looking at just freedom of that information from the outside?
Mr. Hopkinson, is there a provision in the bill draft that allows for seeking permission from the penal institution to take photographs of it from the air, which would then not make it a crime?
Madam Chair, there is that provision that would allow a person to get permission from the individual in charge of the facility to take such photographs. So as long as you get permission first, it would not be a crime. If you didn't, then it potentially could fall under that. If you would like me to go more into the First Amendment issues, I can
Go ahead.
at least somewhat address some of those concerns. Other states have similar language in their statutes, making these types of prohibitions. There's a number of different ways that they have handled this. Some of them are less restrictive, requiring a specific intent to commit a crime. Some of them are in line with what we have here. When we're looking at the first Amendment itself and restrictions on the content, it does not flat out prohibit those restrictions. You just may have to meet a higher standard. In this case, there's the potential for a requirement to meet strict scrutiny, which would require that there be that the legislation be narrowly tailored for a compelling government interest. And so that would be the question. Is this narrowly tailored with to accomplish a compelling government interest? I can't say one way or the other on that, but that's what you would be looking at as far as determining the constitutionality of that provision.
Mr. Hopkinson would be preventing the breakout of terrorists from the penal institution a compelling government interest, do you think?
Madam Chair, there's certainly an argument to be made there.
Interesting. All right.
And Madam Chairman,
Mr. Fuller?
I'll add to that. Courts have held that generally prison security is a compelling governmental interest. Some circuits have said that mere assertion, though, may not be enough to satisfy that compelling interest piece of the puzzle. The Fourth Circuit, for example, would require prison officials to show adequate evidence that the security concerns that prompted the policy are compelling.
Other questions for Mr. Hopkinson? Our Representative Yen?
Madam Chairman, thank you, Mr. Hopkinson. On page 2, line 22, can be expendable or recoverable. What is an unmanned powered aircraft that is not expendable or recoverable? Is this a necessary clause?
Mr. Hopkinson?
Page 2.
Thank you, Madam Chair. I think that's a fair question, Representative Yin. That particular language I pulled, I want to say from Delaware statute, but I can double check and let you know exactly which state that language comes from. And so I can't say offhand that there's any magic to that particular provision in there, but that was something that I'd seen and other states have. So.
Further questions? All right, seeing none, thank you both. Director Shannon, come forward. Good morning, Dr. Shannon.
Good morning, Madam Chair, Co-Chairman Olson, committee members. I'm Dan Shannon, Director of the Wyoming Department of Corrections. If it pleases the chair and the committee, I would just like to discuss a few things. First of all, I want to thank you for taking the time to discuss the draft of Bill 110. I come before you today to discuss a compelling public safety issue. It's not a new one. It's not something that's new to Wyoming or even our nation or our world. I'm only speaking on behalf of the state prisons within our confines. I have no intention of speaking on behalf of detention centers or county jails, as they fall under a different authority and guidance. With that being said, I would just like to go back to my original comment. Prisons consistently in my career, in 37 years, we've always been taught to develop a perimeter. You secured that perimeter, and it served two purposes. One, it ensured public safety for those individuals that it's not external. Number two, it provided a safety barrier or cushion on within that state land that allowed for us to complete our duties without endangering not only our staff, but those who are confined. With that being said, several European, mid-European countries have dealt with this issue for a number of years now. I'm familiar with 12 states that have legislation, and more especially 3. And I believe they are Arkansas, California, and North Dakota, to provide language specifically forbidding surveillance and harassment. With that being said, in the event requests for public information, things that information, I always have to determine and really examine philosophically what our intent and our mission in Department of Corrections is. Is it a compelling safety issue? And that's why I come before you today. I spoke of it's not just unique, this issue, and it doesn't mean it's a bad thing. Just because for my career, we developed the same model that actually it's kind of antiquated if you think about it. Similar to the COVID pandemic, we learned to adjust and do things differently. Now with unmanned aircraft coming forth, I'll give you just one example of speaking with a director from an agency that's approximately 2 to 2.5 times the size of our agency. And just in the month of July of 22, there were 32 sightings on state institutional grounds. 20 of those sightings promulgated contraband discovered on those state institutions, and 10 drones were actually apprehended. With that being said, it doesn't, I'm trying to get ahead of this issue. We've had very small incidents within our state penal institutions. How do we address this? Title 18, US 32 clearly defines that we're forbidden to discharge a weapon to bring down aircraft. I do appreciate the statement of contraband, and I believe the Department of Corrections has no place trying to develop legislative matters. But I think we should provide the information and the evidence of what we're doing with daily to assist and hopefully give some thought. With that being said, we have an opportunity here to promulgate the rules for the DOC. We can secure the area. We can immediately secure the perimeter. Now, for those who haven't worked in a correctional facility, to do an emergency lockdown is an extremely dangerous situation. It's dangerous for our staff as well as inmates confined. Number 2, we notify local law enforcement, and we do a search for contraband. We have no way of knowing what's friend or foe. I can't tell, and the superintendent or the warden of that institution has to make that decision immediately, or that shift commander. What type of instrument is this coming forth? With that being said, there's been question regarding public safety, or is this in the first? I'm not going to discuss the First Amendment, but I'll tell you what the Department of Corrections has done this year. We've opened up to all Wyoming media news sources, all 5 institutions. We invite them, we have, and we've gone to our facilities. With one exception, we don't take photos of control centers, nor do we take photos of without consigned consent of inmates. Why would we do that? And I've been asked the question, what's the difference than Google Earth? In today's technology, even though facility and location, certain locations of facilities are identified for emergency preparedness of different locations and numbers, with things such as Google Earth and what's the difference in that aspect, there's no point in trying to work that. But what we do is we alter recreational times, we alter locations where inmates are confined. It jeopardizes their safety. If a drone was going to drop contraband or flyovers, let's just say for surveillance, I have no way of knowing of the location of that inmate. Are we putting that individual in harm? Are we photographing that location where that person comes out, even though we alter recreational times and locations within the yard? Is that a public safety matter? Absolutely. Is that contraband going to be dropped in a wrong location? Because they have to identify the location or the person. This isn't a still image coming from a satellite system. This is a live feed that's jeopardizing our staff and our inmates at the exact same time, more especially with security threat groups if it's dropped in a wrong area. Now we have a larger issue on our yard as we're trying to confine it. So with that being said, Madam Chair, I'll stand for questions of the committee.
Questions from the director? Representative Provenza? Representative Yen?
Madam Chairwoman, thank you. Director Shannon, so is the issue specifically drones flying over the prison and not beside the prison or anywhere else? It's specifically overflighting the prison itself.
Director Shannon?
Madam Co-Chair, Representative Yin, to me, as I'm responsible for this department, the issue is the introduction of contraband, the potential or attempted introduction of contraband, as well as surveillance, live surveillance within the institution that jeopardizes the safety of those inmates.
And Director Shannon, to answer that more directly, the surveillance of either inmates or correctional officers does not require the drone or the unmanned aircraft to be directly overhead. It could be around the penal institution in a way that allows that surveillance to occur. Is that correct?
Madam Chair, I believe.
The answer is yes.
I believe the answer is yes. I don't fly drones. With that also being said, Madam Chair, with your permission, I'd also like to add, it provides an opportunity to re-victimize our citizens as well, because that very well could be on social media, and I'm aware of other agencies having those issues, which I strongly oppose.
Representative Yen, follow up.
Madam Chairman, thank you. Director Shannon, so does that concern follow towards people surveilling without drones as well?
Director Shannon?
Is that something that happens?
Madam Chair, Representative, and yes, it does. And we do have that within our rules, how to address that.
Follow up.
Madam Chairman, could you Director Shannon, could you expound on a little bit, just a little bit, of how you deal with surveillance that isn't through drones?
Madam Chair, Representative Yin, without being an alarmist or giving things away, there's been opportunities where individuals would attempt to throw contraband onto prison grounds through tennis balls, through different ways. People that got up on high grounds with telephonic instruments. What we do is we dispatch our perimeter, we contact law enforcement, we immediately secure our grounds. Because as I mentioned earlier, I have no way of knowing immediately what the intent. Hopefully it is positive and someone's working, but I can't tell that. So I have to secure that facility at that point, and that's what we've done in the past.
Representative Yen?
Madam Chairman, thank you. So Director Shannon, we don't actually have any rules or statutes against taking pictures from a hill, for example.
Director Shannon?
Madam Co-Chair, Representative Yin, not legislatively, no, just departmental rules.
Director Shannon, what would you do if you saw someone taking photos of the yard with inmates in it?
Madam Chair, if it was an active choice photo, I would secure the yard and notify law enforcement. ask for an investigation.
In your experience, what does that usually indicate?
It doesn't, Madam Chair, it doesn't always indicate what the intent is, but I can't take that chance. I have to make the assumption that the intent is potentially to bring contraband or cause an escape within our facility. Madam Chair, if I may just expand on it one step further, not all our facilities have perimeter fences. We have minimum facilities that people have exposure to the communities and such. That even exposes us more to danger because it's more prevalent to happen there.
Representative Washut?
Thank you, Madam Chair. At the very least, these types of identification, whether it be a drone or somebody on the hillside with a telephoto lens taking pictures of your yard, they're very disruptive to your operations, and you have to take immediate countermeasures. Is that true?
Director?
Madam Co-Chair, Representative Washup, yes, absolutely. My constituents, I'm sure, are much different than yours. And I have to take immediate action. I can't wait. And as I mentioned earlier, not only is it disruptive, it's a safety factor to try to, in a quick, expeditious manner, to secure a facility. That's not always possible.
Senator Kolb?
Thank you, Madam Chair. Director Shannon, is your understanding with the current technology with drones such that you can fly them not over the institution, but say above a height that could peer into the institution and have good viewing inside the institution because of the viewing angle that is currently afforded with today's technology? Can you expound on that?
Director?
Madam Chair, Senator Kolb, I'm actually on a technology committee with other directors, Western directors, and that's being looked at. Departments can purchase ex-military drones, and to answer your question, absolutely.
Further questions for the Director, Representative Rodriguez-Williams?
Thank you, Madam Chair. Director Shannon, I'd just like to get your feedback on some of the language used in the bill, specifically on page 5. Looking at lines 8 and 9, it states that correctional facility may take or authorize the use of reasonable actions to prevent or stop the use of unmanned aircraft systems. Just curious what your thoughts are about the wording reasonable actions, prevent or stop the use of. Does that suffice? And when I think of the language used there, I'd like to insert the word terminate. Director?
Madam Chair, Representative Rodriguez-Williams, I really appreciate that comment, but I would be thankful to have the opportunity to just the way the language is. I don't believe we have the opportunity to terminate, nor do I have the desire. I have the desire to keep everyone safe, and that's my responsibility. Would we, when I say we, I refer to the Department of Corrections, would we secure a drone if possible, if it's on grounds? Yes. Would I, as I mentioned to Representative Washut, would I immediately try to secure our staff and inmates and then notify law enforcement and attempt to obtain the drone? Yes, but I'm not seeking termination, let's say it that way.
Follow-up?
Thank you, Madam Chair. And just a follow-up question. So you talked a lot about securing a perimeter. Do you see the need to include any language in this bill that speaks to the perimeter of an institution or not?
Madam Chair, Representative Rodriguez-Williams, I do not, because it identifies the institution. My understanding, the intent is institutional grounds.
Representative Washut?
Thank you, Madam Chair. Director, the bill draft speaks to the introduction of deadly weapons. I'm concerned a little bit about non-deadly weapons. Should the bill draft to include use of a drone to introduce a weapon, may not be classified as a deadly weapon, but might still be a threat to your personnel or other inmates?
Director?
Madam Co-Chair, Representative Waship, I mentioned earlier, I would certainly welcome that form of language. The concern that I have, and I mentioned earlier, I don't think the Department of Corrections should be defining contraband. The bill clearly states what's unlawful. Now, let's say the example, alcohol. Alcohol is not lawful to obtain. So I don't believe it's Department of Corrections' intent nor wish to try to insert or change the language. But it's Representative Washington, it's one or the other, it's deadly or it's not. So I think we are missing that language.
Further questions of the director? Representative Provenza?
Thank you, Madam Chairwoman. Some of my concerns about the First Amendment issue come out of cases that have been in federal court in Texas that the court has ruled are violations of First Amendment, in part because the press was trying to use drones to photograph. I think there was a fire at one institution and others. And so there's times in which you and your facilities wouldn't be able to give maybe permission because you're dealing with crisis, or maybe, I find you to be very transparent, but maybe we have someone that works in DOC who doesn't want to work with the press as much. And so my concern is that, much like our previous data bill that we brought today to repeal language, that we were going to have First Amendment issues in the courts. And so I'm wondering, if we took out the subsection I on page 4, where we're talking about photographs, surveil, broadcast, or otherwise, and this bill still allowed for you to handle drones that are above your institution, what are your thoughts on that, I guess, is what I would like to know.
Madam Chair, Representative Provenza, I, and more especially, I don't know how I could charge the staff to make that determination. Is that drone have ill intent? Does that have contraband attached to it? Would that drone is only there for surveillance? I'm not able to provide information regarding what another director may do or what the future may behold as far as transparency. But with that being said, from my understanding from correctional security, the number one basis would be to identify. First thing you'd have to do is identify not only the area, but you'd have to identify the individual where you're trying to drop the contraband. To me, that would be no different. We don't permit harassment. We don't permit harassment of animals or wildlife. We wouldn't allow that in a private setting. Someone's being viewed in their home, yet we're exposing individuals, and inmates are our citizens. And we're exposing those individuals to danger from other inmates, as well as I mentioned earlier. I think that videoing I have heard from our citizens within our state that how it re-victimizes folks. So to answer your question, I don't see how it would be possible for an individual to make, that's responsible for security at that moment, to make that judgment call if it's surveillance or not.
Further questions from the director? All right, seeing none, Director, thank you. Please stay close. Committee, Representative Provenza has identified really what is the key issue in the bill regarding the First Amendment concern, which is on page 3 to line 4, which is read together would be on page 3, lines 20 through 22, and line 4, lines 1 through 3. So that's where the committee needs to focus its attention. And I would encourage you to do that. And Representative Provenza identified the concern, and I think some of the media's concern, that they would now be prohibited from flying a drone or an unmanned aircraft over a prison to take photos. Now, assumingly they're taking photos because it's a matter of public concern. So, there are allegations about the prison, and so they're going to go do an investigation, and there's a matter of public concern because it's a public penal institution. And certainly that would be an appropriate action on the part of the media. the Department of Corrections' defense to that is, well, we don't know that that's the media responding to a public concern. That could be a bad actor involved in criminal activity or otherwise, right? In addition to other concerns regarding the Fourth Amendment protections of the inmates or just the treatment of them as regular citizens, of them being able to go outside and not being photographed by who knows where, and then where those photographs go from there. So those are some of those concerns, right, that have to be balanced and carefully considered by this committee. Both of those concerns being reasonable and careful. I don't know the circumstances surrounding the fact pattern in the Texas case, but I can't imagine a more frightening situation for a prison warden to be experiencing a fire. And then all of a sudden there are drones overhead, and what that means, and having be able to evaluate whether or not that's your local news media or some other coordinated effort of some type of an intentional action that is connected to the fire, right? That is alarming at most, right? And so, this requires a great level of responsibility between our First Amendment protections and the duties and responsibilities associated with our penal institutions in this country, right? So rather than the media simply reporting and criticizing the work of this committee, it would be helpful to hear comments and participate in this process. That would be helpful. So just some considerations there as we continue to move this bill forward and identify those concerns carefully for this committee. Further public comment on this bill? Courage. No further public comment on this bill. Public comment is closed. Anyone online? No, okay. All right, public comment is closed. Committee, back to you. Moved by Senator Kolb. Is there a second? Seconded by Senator Cooper. Further discussion by the committee? Representative Provenza.
Thank you, Madam Chairwoman. I guess in discussion of the bill, it's obvious what my concerns are at this point, and trying to weigh how do we ensure public safety versus protecting our freedom, our First Amendment freedoms. I'm wondering if maybe having some provision of, and maybe it's in Romanet I on page 4, while directly above, or if the committee would rather do something along the lines of allowing for this, and with the concern of intent coming in. I don't know exactly what we need to do, but I do think if we do nothing and we bring this bill forward as it is, we will have constitutional problems. And as we heard earlier today, that costs us $600,000 in one case, and I certainly don't want to put that burden on taxpayers. So I would be open to ideas from the committee.
So Representative Provenza, one thing that I look at is on page 3, line 20, and curious to hear LSO's comments about this. It says, except as authorized by a person in charge of the penal institution. And so my thought as an easy remedy to this would be for the news media to have some type of MOU with the penal institution when it intends to cover a story or some emergency is occurring, some type of an agreement allowing for that to occur. And I know the media's consent from the government, how can that ever be okay, right? But it's a balancing of interests there. So Mr. Hopkinson or Mr. Fuller, kind of thoughts on whether or not, except as authorized by a person in charge of the penal institution, provides any kind of constitutional protections?
Madam Chair, I would say that I think that would absolutely factor in when you're looking at whether or not this is narrowly tailored, having those kind of exceptions, I think would factor into that analysis. But I can't go as far as to say one way or the other on how that may play out, but I think it makes a difference.
And recognizing it's just your opinions, but is it your opinion that this particular section, and of course the entire bill, but identifying this particular section's concerns, is it unconstitutional on its face? Da, da, da.
Madam Chair, what I can say is other states have similar provisions. I'm aware of the Texas case that's pending. Their provisions, I think, are distinguishable from the ones that we see here. And from what I can see, some of those other states that have those prohibitions on photography, that sort of thing, their provisions have not been challenged, at least from the quick search that I was able to do on those. So I don't think that this would be blazing new ground, but I guess that's as far as I can say on that.
Mr. Fuller?
Yeah, Madam Chairman, you know, the question of constitutionality, I think, is ultimately for the body to decide in the first instance, subject to the governor's review and then subject to challenge after that. What I will say is this: the bill draft, as drafted right now, nothing in this would preclude anyone really from going to the person in charge of a penal institution and seeking permission to fly a drone for any number of purposes, you know, to gain that permission and fly the drone in accordance with, you know, I would assume any requirements that the Department of Corrections would stipulate to in that.
Representative Oakley?
Thank you, Madam Chair. Are there any other statutes that have a specific media carve out, or is doing that kind of stepping in it to begin with?
That was artfully asked. Thank you. Are we stepping in it? Mr. Hopkinson?
Madam Chair, Representative Oakley, I do believe there are some states that have carve-outs. I can certainly be happy to look into that a little more detailed for you and provide information on what that looks like.
Mr. Fuller?
Yeah, Madam Chairman, I echo Mr. Hopkinson's thoughts. What I would note is that Texas case that has been mentioned, their law includes 22 different exceptions with various terms and words used in those. Most pertain to law enforcement. Some do not, though. Some referenced use for commercial purposes, and that was one of the phrases in that law that the federal judge found at issue in declaring that statute unconstitutional. So that law does have numerous exceptions, you know, specific in nature, unlike this one, which is broad but discretionary.
Representative Provenza?
Thank you, Madam Chairwoman. Are there statutes in our public records law that would require DOC or correctional facility to be transparent in such that if the media approaches them about photography media in any way, that they would be required to allow them to do something such as collect footage?
Mr. Fuller, Mr. Hopkinson, give you a minute to go look at those statutes. My recollection, the answer to that is no. Again, I would think that there could be some solutions moving forward about what to signal to an institution that it's the media as opposed to a criminal actor or some bad actor or some other unknown actor. You know, that clearly identifying yourself is helpful to understand whether or not there's a danger to the institution, can be thoughtfully considered, right? And the type of notification or identification on the unmanned aircraft, I think that there's a lot of solutions that can be navigated. Of course, hearing from the media would be real helpful. Okay. Senator Kolb?
Thank you, Chairman. Is there any ability to appeal the decision of Mr. Shannon if there was a disagreement with I guess, the authorization of flying some sort of UAV around the facility? Is there a mechanism, or could there be a mechanism that would allow that process to be dealt with in court?
Mr. Fuller?
Yeah, Madam Chairman, Senator Kolb, I think if it pertains to the First Amendment, I would assume that one avenue would be a 42 U.S.C. 1983 option, suing in federal court that a certain action has violated the First Amendment.
I also think there's another statutory remedy associated with an adverse action by a government entity in the Wyoming Administrative Procedures Act, I think.
Well, Madam Chairman, if it concerns a rule that the department has promulgated, there is an explicit exception, and I don't recall the number. It's in the bill draft 25-1-105 or 101. There is an explicit exception that any rules that the department promulgates are exempt from the Administrative Procedure Act,
Right.
and those are expressly excluded from judicial review.
Good. Representative Yen?
Thank you, Madam Chairman. Would it make sense to have a situation where we have a shall clause that shall give permission to some sort of credentialing of media on taking photos on penitentiary grounds?
That's a thought, or the Department of Corrections shall promulgate rules and regs associated with granting permission to the media, something to that effect. Thoughts for the committee to consider? Senator Kolb?
Thank you, Madam Chair. And that media would be a major media company, or just some fellow that decided he's a media company and runs around with a drone? Thank you, Madam Chair.
That's a great question. Representative Washit?
Thank you, Madam Chair. Just a question for the attorneys. Would this potentially be one of those statutes where a severability clause might be beneficial, that should there be a First Amendment challenge to the photographing, surveilling aspect of this, that the rest of the statute could be preserved?
Mr. Fuller?
Yep, Madam Chairman, Representative Washit, I don't recall exactly where it is. In Title 8, though, there is language that does already, for any statute, specify that if some portion, the intent is to sever that portion as best as possible.
Further discussion from the committee? Representative Yen?
Madam Chairman, thank you. So maybe quick question for Director Shannon is whether or not they already have a credentialing process for press to tour their facilities, et cetera.
Director Shannon?
Madam Chair, Representative Yen, we have a credentialing process for all citizens on how they would enter the facility and tour. It would include background checks. It would include association with those who are confined, intent of the visit, things of that nature. It would be for our volunteers, it's for our state employees, for visitors, for guests. The few exceptions are state officials such as parole board, governor's office, law enforcement, things of that nature.
Representative Yen?
Madam Chairman, so there's no, Director Shannon, so there's no separate determination of who is or isn't considered press already in your rules and regulations?
Director?
Madam Chair, Representative Yen, everyone who requests that type of visit or oversight is treated equally.
Further questions from the committee? All right. Senator Cooper?
Thank you, Madam Chair. Director Shannon, on page, whichever it is, section I, photographs, surveil, broadcast, and otherwise record the question that we're discussing through the use of unmanned aircraft system. Is this already forbidden with manned aircraft systems?
Director Shannon?
Madam Chair, Senator Cooper, it is not through the FCC. It is not through the FCC. It is not.
And so Director Shannon, to clarify your answer there, the FCC is the organization that regulates manned aircraft. They do unmanned too, but
Yeah.
is that your?
Madam Chair, I
point?
thought that's what Senator Cooper said, manned aircraft. I apologize. if
No,
I
he did, yeah.
heard me correctly.
All right, thank you.
Yeah.
Representative Provenza?
Thank you, Madam Chairwoman. Director, in the last meeting, you mentioned that you were talking with other DOC reps about federal legislation for this to make sure that we have a blanket overall federal guideline that says you can't fly over correctional facilities. Do you have an update on that or where the status of that?
Yes, Madam Chair, Representative Provenza, there will be committee hearings in October of this year, which correctional directors will attend and try to support them. With your permission, Madam Chair, I'd also like to expand just a hair further on Representative Yin's question. The credentialing is no different than we have many contractors, many deliveries. We have religious volunteers, things of that nature. Everyone goes through the same process. The media participates in the same process. It would be the same. So I'd just like to expand on that. Thank you.
Representative Washut?
Director, if we included language in here that said that the person in charge, the default is to authorize for bona fide news media sources to photograph, and that it still gives some discretion, but the direction from the legislature would be that you should grant permission to the news media unless you can demonstrate a particular threat or reason not to. Would something like that be acceptable to the Department of Correction?
Madam Chair, Representative Washut, absolutely, it would be acceptable. The only exception that I could consider, and it would be a temporary, in the event that it was an immediate threat or a safety concern. Beyond that, I have no issue with that.
All right, final questions to the director. All right, Director, thank you.
Thank you.
Okay, we're back to the committee. Representative Zwanitzer called question on the bill.
If there's no more public comment, yes, I'd move the bill. And then I'd call question.
Question being called on the bill.
Madam Chairman,
Representative Yen?
I'll make a motion for an amendment. So on page 7, the new language for subsection H, maybe a little bit conceptually here, the ability for the public to obtain permission. It shall promulgate rules specifying reasonable actions, as well as the ability for the public to obtain permission for photographing a facility ahead of time. Just so that there's explicit language in there that the public can pursue permission, even though we have that additional part in the original section that we've added.
Is there a second? Seconded by Provenza. Representative Yen, would you kind of restate your motion?
Thank you, Madam Chairman. Yes. So my motion would be to add on page 7, line 7, and the ability for the public to obtain permission to photograph a facility with an unmanned aircraft.
That's the motion. Senator Cost, discussion?
Thank you, Madam Chair. And does there need to be any sideboards on that, or is it all right to just say the public to obtain permission? I'm wondering if we're opening it up wider than intentionally needed.
Representative Craigo?
Thank you, Madam Chairman. Just, I guess, something to think about. I wonder if that already falls under the Public Records Act. Do we need additional language within this bill to cover that? I don't know, but it's something to think about.
Are penal institutions covered in the Public Records Act? Director Shannon, do you know? And how are they covered? Are there exemptions or exceptions under the Public Records Act for penal institutions? Mr. Fuller?
Yeah, so Madam Chairman, I guess the distinction, I think, with the Public Records Act, first, there is a required withholding of records that concern physical security. I don't believe that subsection in it's 16.4203D has been litigated. I have to double check that. The distinction there, though, would be access to a record that the Department of Corrections has already created. I'm not sure this question here seems to be a little different. You know, should the Department of Corrections offer access to a facility for the purposes of creating, you know, what would be a private record, or in the case of media, a public record in that sense. So I think there is a distinction between accessing something that the Department of Corrections has created versus here, where I think what's being contemplated is someone else having the ability to create a record by photographing or videoing a facility.
So let's get back to the motion, just to kind of keep us on track. I think Representative Yen's motion was to have two requirements on page 7, lines 4 through 7. And so that in addition to the Department of Corrections being required to promulgate rules specifying reasonable actions a person in charge of the institution may take to stop or prevent a violation of a crime, that the Department of Corrections would also be required to promulgate rules specifying the process for allowing access to the penal institution for purposes of photographing and other surveillance. Is that correct?
Madam Chairman, that's correct.
Okay, so that's the motion. That is what we're discussing now, is the second requirement requiring the Department of Corrections to promulgate rules. Representative Yen.
Madam Chairman, thank you. To expand on that, you know, again, this is, for them to promulgate rules means that they can put the sideboards on what is and isn't appropriate for this process, but also for the public, gives them an explicit way to understand, okay, so I want to take photos of this, or I want to be prepared to take photos in case there is a fire. How do I make sure that I have permission ahead of time to do that? And so I think the appropriate sideboards are there by giving the agency the way to set those sideboards. And I think this is a nice middle ground.
All right, that's the motion. Further discussion? Senator Kolb?
Thank you, Madam Chair. I think page 7, under H, covers that. To promulgate reasonable rules, reasonable actions, a person in charge of a penal institution or correctional facility, hard to read without my glasses, and may promulgate. So anyway, the point is that the person in charge will promulgate reasonable rules. I think it's already written here. I think if they're unreasonable, they'll be challenged, and I have faith in the people in charge of these promulgation of these rules that it will be, in fact, as stated, reasonable. So I think it's already written in the current bill draft as presented. Thank you.
Senator Cooper?
Thank you, Madam Chair. I'm wondering if better language than actually addressing the photography would be to address exemptions to the statute as written, similar as you're making rules to prevent a violation, but you should be able to promulgate rules to allow for exemptions to the statute.
Director Shannon, can you please come forward? And Director Shannon, is Representative Yen's motion redundant is essentially what I'm asking. Do you already have promulgated rules for the public's access to a penal institution, whether that be in person or through some other type of technology?
Madam Chair, yes, we do.
And would that cover the concerns that we have discussed here today, those rules?
Madam Chair, yes, it would, but they would need to be expanded upon to include aircraft, things of that nature.
Okay. So Director Shannon, do you think that it's necessary for this committee to put in statute for you to do that, or do you intend to do that?
Madam Chair, it's my intention to create those rules.
Representative Yen?
Madam Chairman, so Director, would you be opposed to the amendment?
Director Shannon?
Madam Chair, Representative Ian, I believe I'm probably sued with litigation more than any other state employee. And if my rules don't fit within constitutionality, at the wildest extreme, I'm challenged on it. With all respect to the amendment, I believe it's redundant to what we're trying to accomplish, which is public safety for those confined and those working within the penal institutions.
Thank you, Director Shannon. And then I'll direct the question to LSO staff. If you think that adding into the statute that language directing the department to promulgate rules associated with this process helps add to the argument that it's narrowly tailored to meet the constitutional muster? Or do you think it doesn't matter?
Madam Chairman, I very hesitant to answer whether, certain language would or would not impact the constitutionality. I would note two things, two observations. First,
It's too easy.
the rules in the language on page 7 just talks about rules for really the actions the department can take to address drones that are flying over for the purposes that are in subsection B on page 4. The second thing I would note, 25.1.105A says that the Department of Corrections can promulgate rules necessary to carry out its functions. It's an extremely broad grant of rulemaking authority.
Further discussion? All right, seeing none, question having been called, all those in favor of Representative Zian's motion, say aye. All those opposed, say no. No. That motion has failed. Representative Provenza?
Thank you, Madam Chairwoman. It sounds like we have a lot of questions and concerns about what the constitutionality is. We have some question marks about potential litigation that's going on that maybe we should know details to. I might prefer that we move to bring this bill to the next meeting, have some of these questions answered about this constitutionality or other litigation that might become an issue with the First Amendment in that that numerate I, with potentially time to draft more thoughtful amendments of how we can move forward with this, so that we each know exactly what we're doing here. Because I don't feel comfortable voting for this bill today with the questions that we have in place.
Further discussion from the committee? Representative Zwaniter?
And I just want to make sure the motion on the floor is to make it a committee bill for 2023 and move it directly to the session right now.
Correct.
That is the motion. Okay.
Correct. Further discussion? I think to respond to Representative Provenza's concerns, I don't know that we'll ever have the answers concerning the constitutionality of a bill draft when those concerns are presented. We've received an opinion from LSO. I know they get nervous when I say that, but there's no staff comment there that says, warning, legislature, this may be in violation. We've had a robust conversation about those concerns, and I don't believe that the bill draft is unconstitutional. Could a court find it based on a particular fact pattern that is presented? That's possible, but I don't think that that is clear or that the bill draft is unconstitutional on its face. Now, a court could find me wrong, but that's my thought, and I believe that that's LSO's opinion, that we have done our best to make it as narrowly tailored as we can to meet a compelling government interest, which has been clearly articulated and identified by Director Shannon, to balance all of those interests, both for the legislative's concerns over the executive branch, of which the Department of Corrections is, and our ability to evaluate and understand what's going on there. The fourth arm of government, which is the media, and their concern to make sure the public is aware of what's going on in our penal institutions, as well as the safety and security of those penal institutions themselves. So I do think that the bill strives to address all of those concerns and balances them carefully. So I'm prepared to move the bill draft forward, but further discussion from the committee is certainly warranted. Roll call vote on the bill.
Senator Cooper,
Aye.
Senator French excused, Senator Kolb,
Aye.
Senator Cost,
Aye.
Representative Crago,
Aye.
Representative Larson,
Aye.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Washit,
Aye.
Representative Rodriguez Williams,
Aye.
Representative Yen,
No.
Representative Zwanitzer,
Aye.
Co-Chairman Olson,
No.
Chairman Nethercott,
Aye.
that passes.
All right, with that committee, we will move on to LSO Bill Draft 112, our last trespass bill for the morning. We are 12 minutes behind schedule, but I think we're doing pretty well. This bill is trespass by small unmanned aircraft. Mr. Hopkinson.
Thank you, Madam Chair. Again, David Hopkinson with the LSO, walking through 23 LSO 112, trespass by small unmanned aircraft. At the last committee meeting, there was some discussion about trespass in general, and specifically, of course, related to drones. One of those discussions was with respect to the restatement of torts, specifically Section 159, subsection 2. And there was the request that we codify that and make it a criminal offense. And so what we see in this draft is essentially kind of a modified version of that tailored to Wyoming that provides creates a new section 63308 and provides that a person is guilty of trespass by small unmanned aircraft if the person causes a small unmanned aircraft to enter into the immediate reaches of the airspace over the private property of a landowner, and the entry substantially interferes with the landowner's or his authorized occupant's use and enjoyment of the land. And then it clarifies that and spells out that those definitions for aircraft, unmanned aircraft, and small unmanned aircraft mean as defined in 14 CFR 1.1, those regulations, and limits them to being as they are defined as of July 1st, 2023. And we can see those definitions in the staff comment. So essentially, for this bill, a small unmanned aircraft, which is what would be prohibited, is an unmanned aircraft weighing less than 55 pounds on takeoff, including everything that is on board or otherwise attached to the aircraft. Subsection B provides that this would be a misdemeanor punishable by not more than 6 months in jail, a fine of $750 or both. The act would be effective July 1st, 2023. And with that, I would stand for any questions.
Questions of Mr. Hopkinson? Senator Cost.
Thank you, Madam Chair. Is there a limit to where that airspace is?
Mr. Hopkinson?
Madam Chair, Senator Cost, the immediate reaches is potentially an ambiguous term. That's how it is in the restatement. It just refers to the immediate reaches. As far as an exact distance, there really isn't one that's clear. And so at the end of the day, what it would boil down to is whether or not a jury felt like the distance that it was at was within the immediate reaches of those space. So certainly a question for the committee if they want to clarify or make that more explicit what that distance might be. But it is, there is some ambiguity or at least some vagueness as far as where that would actually fall.
Representative Provenza.
Have we defined enjoyment of the land in statute?
Mr. Hopkinson, can you provide the history of that? Reasonable person standard? History of use and enjoyment of the land, which is a term of art in our law in America. Mr. Hopkinson, I'm sure you're not prepared, buying you some time. The other lawyers are not making eye contact.
Madam Chair, I don't have the specifics on that one. I'd certainly be happy to provide that as far as the use and enjoyment of land, but it's been around. That phrase has been around for a while. And so again, at the end of the day, since this being a criminal code, be for a jury to decide what constitutes the enjoyment or the use and enjoyment.
Representative Craigo, any thoughts on use and enjoyment of the land?
Thank you, Madam Chairman. It's just common law terminology. I think it.
Before the Queen? Before the Queen's time?
Probably before the Queen, yes, ma'am.
All right. Further questions for Mr. Hopkinson? All right, seeing none, we'll turn to public comment on this bill. Any public comment? All right, welcome, Mr. Magagna. Good to see you again.
Thank you, Madam Chair. Jim McGatton with the Wyoming Stockgrowers Association. Just wanted to express our strong support for this bill. We think it very directly addresses major concern that we've had with the use of, in particular, of drones and other similar aircraft today, and believe that there's so many ways in which those aircraft can interfere with use and enjoyment of the land that having this fairly broad in that sense and is critical to making this work effectively. With that, let's just express our support and be happy to answer any questions.
So, Mr. Magagna, Representative Provenza once again has identified a unique term in the bill. And Representative Craigo correctly identified that use and enjoyment of the land, as you well know, Mr. Magagna, is the common law, which is the civil law in this country and others. Do you have any concerns about bringing in that common law, civil law construct into our criminal code and then creating what would be a subjective intent potentially or subjective requirement as an element within the criminal code? Because if I'm a prosecutor, I would have to prove that the aircraft, that the drone actually caused the landowners, interferes with their use and enjoyment of the land. And so how does a prosecutor do that?
Madam Chair, not being a prosecutor, I'm not sure I know the answer, but I do believe you raise a valid concern there when you bring this into the criminal law. And perhaps just if we're talking about the use of the land, the use could be for enjoyment. It could be brought in that sense without a need perhaps to include that nebulous term of enjoyment that's in the civil code and bring that over into the criminal code. And then it would depend on what my use of the land is as to whether or not the unmanned aircraft had interfered with that use.
All right.
But the use could be enjoyment, it could be whatever that may be, it could be farming, running livestock, hunting, whatever else it could be.
Thank you, Mr. Magagna. Representative Oakley, how would you prosecute this?
Thank you, Madam Chair. I think Mr. Hopkinson said it from the very beginning. That's for a jury to decide. I don't think there's any problem here of mixing civil law and criminal law. You can, I mean, it's up to a jury then to decide first for the landowner and then law enforcement and then a prosecutor to say, yes, we agree that this, the way this was used, it's fact-driven, fact-specific, as all these cases, as any case that goes, that's criminal law is, and said, yeah, this interfered with the landowner's use and enjoyment of their land. And then with any specific fact of the case, the jury says, yes, it did or it didn't. So it means exactly what 6, if it's a misdemeanor, 6 people say it does. And then that's, of course, after the landowner, law enforcement, and a prosecutor agreed that they believe beyond a reasonable doubt that it interfered with the use and enjoyment. But that doesn't mean we can't create the statute and prohibit it.
Representative Oakley, what does the jury instruction say for how use and enjoyment would be defined?
Depends on if it is defined. If not, it's exactly what the jury thinks it means.
Mr. Fuller, Mr. Hopkinson, do you believe that the statute could be unconstitutional for void for vagueness or overbroad? Think about it. Further questions for Mr. Magagna? He's nervously still in the hot seat and doesn't know why. Thank you, Mr.
Madam Chair.
Magagna. With that, we'll go to Ms. Shaner. Welcome.
Thank you, Madam Chairman, members of the committee. My name is Mary Ann Shaner, and I am here today on behalf of State Farm Insurance. State Farm would like to request an amendment to the bill related to commercial use of drones. State Farm was the first insurance company to be granted federal approval from the Federal Aviation Administration to use drones in its business. State Farm uses drones for purposes of catastrophic assessments, underwriting, and claims. State Farm seeks an amendment to the bill to clarify that continued use for drones for these commercial purposes. An amendment was just passed out to you, and we would propose on page 2, line 8, insert subsection B. This section does not apply to a business entity doing business lawfully in the state using small unmanned aircraft for legitimate business purposes and operating the small unmanned aircraft in a manner consistent with applicable FAA rules, licenses, or exemptions. APCIA, the American Property Casualty Insurers Association of America, also stands in support of this amendment. I'd stand for any questions and appreciate the opportunity.
Thank you, Ms. Shaner. Questions for Ms. Shaner? Representative Zwanitzer?
Thanks, Madam Chairman. So I run a private investigation business and I want to investigate someone. Am I not doing a lawful business for business purposes? Even the landowner might not agree with that, but that's my concern with the language, that sometimes legitimate business purposes don't override private property rights. And in your testimony,
Ms.
I would
Shaner?
hope that someone who's got an insurance claim would grant access, or there would be a way to approve a drone on their property to take damage photos, whatever it might be.
Ms. Shaner?
Madam Chairman, Representative Zwanitzer, I think that there's 2 parts to that question. The second part of this amendment is that you are operating it with applicable FAA rules, licenses, or exemptions. State Farm does have FAA licenses in order to be operating these drones. So I think that the amendment provides broader protection than just, a business claiming they're a business going out there for commercial purposes. The second part to your question is, of course, the policy documents would allow for you to be on the property. However, we do think that clarification in the law in a statute like this is important.
Further questions of Ms. Shaner? Senator Cost?
Thank you, Madam Chair. And I understand the intent with the smaller unmanned aircraft. There are flyovers in areas where gas lines are and all, where large companies are flying to check their lines and all. That's not covered here. I'm concerned about their coverage and I'm going to keep hanging on to one worry that I have, and that is with our crop sprayers and all, when they're dropping down to spray crops right next to other areas, is there going to be violations and those types of things that need to be considered in the amendments as well?
Representative, or Senator Kolb?
Thank you, Madam Chairman. Well, I just had a general statement about those list of exemptions and exclusions I get with my insurance policy written by attorneys and are so great, and I need a magnifying glass to see them all. Is there really would there be an issue with your industry just inserting a right to do what you're asking, this exemption to do? Thank you.
Ms. Shaner?
Madam Chairman, Senator Kolb, again, I do think that the insurance policy documents will deal with this issue. However, we do think that it's necessary to have the clarification in statute with such a broad criminal penalty being put into statute.
Further questions of Ms. Shaner? All right, seeing none, thank you.
Thank you.
Further public comment on the bill? Seeing none, public comment is closed. No one online?
Yes, Madam Chair, we have Brett Moline.
Great. Welcome, Mr. Moline. If you'd introduce yourself again to the committee.
Thank you, Madam Chairwoman. Brett Moline of Wyoming Farm Bureau. I'm sitting firmly in support of this bill. I think this is the right direction to go. I will point out that one thing we don't want to stop is people that have the legal right to come on. And I'll use power lines for an example. They have the right to come on to maintain and repair their infrastructure. And in many times we'd rather have them use a drone rather than driving through the pasture or crop, our private property. If they can identify where the problem is, that cuts down some other problems. So, but I think they already have the ability to repair and maintain. And so I don't think this bill probably affects them. I'm not an attorney, but I think they're okay. And with that, I would sit for any questions, sitting in support of this bill, ma'am.
Questions for Mr. Moline? All right, seeing none. Thank you, Mr. Moline. All right, further public comment? Anyone else online? No. All right. Public comment is closed. Committee, back to you. Moved by Senator Kolb, seconded by Cooper. Discussion. Representative Crago? No. Representative Crago, your thoughts on this bill and your ability to prosecute it successfully?
Thank you, Madam Chairman. I would agree with Representative Oakley that these are just elements that are going to be left up to either a judge and or a jury, whoever the trier of fact is in the particular case. And it's like any other crime. We have a list of elements we have to prove. They will have to prove those. And I guess I would direct the committee's attention to the language substantially interferes, right? I mean, I think that's the language that's the qualifier within the proposed bill draft that protects all of, or addresses, I guess is the right language, addresses all the situations that the committee has brought up and that they're really talking about. For example, Senator Cost talks about the people spraying weeds. You still have to prove that they were substantially interfering with the landowner's ability to use and enjoy his land. Weed sprayers aren't going to be doing that. I mean, they've been doing that for years and decades. And so, I mean, those things play into whether or not you're able to prosecute that crime. We're talking really about what I see as a discrete set of circumstances where somebody is intentionally flying a drone down to, I mean, this is the point of the bill, to prevent people from flying a drone into your private property, into your backyard, videoing what you're doing while you're sitting in your backyard. I mean, that's what we're thinking about here. We're not trying to get to these other situations, and you're not going to be able to prove these other situations. You take the power company, for example. I think Mr. Moline accurately described, they have easements. They have the ability to fly the power line. They don't need permission. They already have that. And so I think all those things are protected. I am not worried about the ability of being able to prosecute this crime. I'm quite confident Representative Oakley could do so.
Representative Washit?
Thank you, Madam Chair. I don't doubt that the prosecutors could prosecute these cases. One is unless you capture the drone, I don't know who you're going to charge or how you're going to figure out, because oftentimes the operator is distant away from where you discover the drone. And I think about it in terms of an urban municipal area. I have a utility easement that runs through my backyard. The last 10 feet of my backyard is a utility easement. So this bill draft says over your private property. So if my neighbor has a drone flying over his property, he can still video everything I'm doing in my backyard. That may make enjoyment of my backyard less possible, but it's not going to be a violation of this ordinance. And I just think about people calling their local police department saying, hey, there's a violation of the Drone Act here, and they got a guy flying a drone, and then trying to investigate those cases and pinpoint, is the drone over your property? Is it over your neighbor's property? Is it over an easement? I think from an enforcement standpoint, it's more complex than from a prosecution standpoint.
Further discussion? Representative Oakley?
Thank you, Madam Chair. I guess just for further discussion to Representative Washit's points. So it started out with, if you don't know who was manning the drone, and it just goes back to this over and over with, but that's a proof element that law enforcement and then prosecution would have to know. So if they don't know it, then there's nobody to charge. I understand what you're saying, that maybe this wouldn't make it so 100% could be fully investigated, but that's with every crime, right? We have vandalism all the time, but we don't know who did it. So there's nobody to charge. Vandalism's still illegal, but just because you can't necessarily, prove every element, that's an element to prove who did it and who to charge. But I don't consider that relevant on if you're charging somebody and you can prove all these elements. That's what this charge would allow. But again, all criminal acts require that you can prove every element, including, of course, who the suspect is. As far as investigation, that's what law enforcement does. Law enforcement is called out for dog at large, for just for helping people. Our deputies change tires all the time. If somebody was, a landowner feel like they were substantially interfered in the use and enjoyment of their land, I think law enforcement would gladly do their job and investigate the case. So I don't see the fact that of it burdening law enforcement to the point of not passing a law if it's something that some landowners want, which I think we've heard testimony that they do believe there is a need for it. So that's my response to those two points.
Representative Rodriguez-Williams?
Thank you, Madam Chair. I just question whether or not there needs to be an exception created in the bill for exigent circumstances, specifically for law enforcement, fire, and game and fish. In my neck of the woods, we get grizzly bear, and sometimes game and fish tracks those bears to locate them. And then I'm also specifically thinking about undercover operations with DCI and so forth. And so just curious what the committee's thoughts are on that.
Further discussion from the committee? Question being called on the bill.
Madam Chair,
Mr. Hopkinson?
I was trying to find an opportune moment to jump in. One thing I would bring to the committee's attention for consideration on page 2, line 7, It has the date there, July 1st, 2023. It may make sense to tweak that and even change the date perhaps to today. What that's really doing is locking in what the definition is. And so if we left it at 2023, it could potentially change outside of the scope of this legislature. And so it may make sense to just change that date, September 13th, 2022, or whatever the committee sees fit.
So you have to look at the bill draft. Everyone go to page 2, line 7.
Yeah, Mr. Hopkinson, I guess I'm a little confused because isn't your date filler anticipating the date of the passage of the bill that we would, because it's not gonna, today's date wouldn't, I mean, it's based on our decision today, I understand that, but,
It's locking the definition in time.
but
So
we
everyone
would
knows what
know
that
if there
means.
were a bill during the session that would deal with the definition.
Madam Chair, it's referring to a federal regulation.
federal.
And so if the federal regulation were to
have to look
change
at the
between
bill.
now and 2023, the definition could be something unintended.
The advice of Mr. Hopkinson is to change the date on page 2, line 7 to September 13th, 2022, or any date similar to that. Senator Kolb?
Amend as indicated to today's date.
Is there a second? Seconded by Senator Cost. Discussion on the motion. All those in favor say aye. It's pretty simple. Representative Provenza?
Thank you, Madam Chairwoman. Sorry, this is rather simple. I wanted to just kind of get a clarification, a reminder as to when we were in the last meeting, we brought in, I know we had discussion about including the federal definition, and I'm wondering exactly why instead of using our own, just to refresh my memory.
Mr. Hopkinson?
Madam Chair, as far as the reasoning for using the federal code is simply to kind of for conformity across the board with understanding what that was, makes the bill draft slightly shorter. But if you would prefer for us to take the language in the federal code and stick it right into the bill draft, that's a simple change as well.
Committee members, if you would use your computers and type in 14 CFR 1.1. You have two options right now for what to do. You either vote for Senator Cost's motion and you vote aye, or you vote no, and then the second motion would be to add the language as currently existing of 14 CFR 1.1 into the statute. Question on the motion. All those in favor, please say aye. Aye. All those opposed, say no. Say no. No. That motion has passed. Division being called. All those in favor, please say aye. Or raise your hand, aye. Sorry.
Raise your hand and say aye.
Let's do it together. Has emphasis. Okay. You have the vote count. Raise your hands high. Voting aye for Senator Kolb's motion. All right, all those opposed, raise your hands. What is it? It passes. That motion has passed.
Spicy.
Further discussion on the bill?
There was a
I think the public wants a roll call vote on that. Just kidding. Just kidding. All right, further discussion on the bill draft? Question being called, roll call vote on the bill.
Senator Cooper? Aye. Senator French excused. Senator Kolb?
Aye.
Senator Cost?
Aye.
Representative Crago?
Aye.
Representative Larson?
Aye.
Representative Oakley?
Aye.
Representative Provenza?
No.
Representative Washit?
No.
Representative Rodriguez Williams?
No.
Representative Yin?
No.
Representative Swanitzer. Co-Chairman Olson.
Aye.
Chairman Nethercott.
No.
You would have had me, that amendment had gone the other way.
That passes.
All right. All right, committee, we are moving on to our next subject for the morning, which is violence against healthcare workers. We have 23 LSO 0088, version 5, assault and battery against healthcare workers. We can have LSO present this bill draft.
Yep, Madam Chairman, this bill draft, the committee requested a bill that would create the offenses of assault, threat of violence, and battery against healthcare providers, and the bill specifies penalties for those offenses. So going to page 2, line 1, are definitions that are used in this new section. The definitions of assault and battery are the same as those in current statutes. So assault would be if a person having the present ability to do so unlawfully attempts to cause bodily harm to another. Battery is if a person intentionally, knowingly, or recklessly causes bodily injury to another person by use of physical force. The definition of healthcare provider is an existing statute. That language is in the staff comment on page 3. Threat of violence is an express or implied threat where the person threatens to commit an offense involving bodily injury, death, or property damage of $1,000 or more, and acts with the intent to place another person in fear of bodily injury, serious bodily injury or death, or makes a threat that is accompanied by a show of immediate force or violence to do bodily injury to another person. This definition is based on Utah law. The $1,000 threshold is a placeholder, but tracks with felony property destruction. So that is the reason for that, that figure there. The staff comment on page 3, I've already noted that the first two parts of that, the last part on page 3, line 19, is just a consideration for the committee to consider whether family members of healthcare providers should be included in the offense. In some states, for example, Wisconsin, which I believe was cited at the last meeting, their law does include family members. Page 3 is the elements of the offense of assault against a healthcare provider. So at the bottom of page 3, line 34, you have to commit an assault against a healthcare provider. You have to know or reasonably should know that the person is a healthcare provider at the time of the assault, and then the healthcare provider was performing duties within the scope of his authority or employment. The staff comment on page 4 is just flagging for the committee whether the language reasonably should know should be in the knowledge paragraph, and that consideration would equally apply to the offenses of battery against a healthcare provider as well as of threat of violence against a healthcare provider. Page 3, page 4, line 23 is the offense of a threat of violence against a healthcare provider. Requires a person to make a threat of violence, which is defined. The person must know or reasonably know that the person is a healthcare provider at the time of the threat, and then the healthcare provider is performing duties within the scope of his employment. Page 5, line 9 are the elements of battery against a healthcare provider. Similarly, there must be a battery against that healthcare provider. The person committing the battery must know or reasonably should know that the person's a healthcare provider, and then that person was acting within the scope of his or her employment duties. The penalties, which are on page 6 of the bill draft, are pursuant to the committee's instruction with the motion, the same as those for simple assault and battery. So simple assault would be a fine of not more than $750. And then battery against a health, and that would also be a threat of violence, so just a fine. Battery would be punishable by imprisonment for up to 6 months, a fine of not more than $750 or both, and then probation may be extended for battery up to a year. That is consistent with our current just standard battery offense. The staff comment on page 7 just lists some other considerations for these new offenses, whether they should be included to the list of offenses that form a pattern of a criminal street gang activity. The reason that consideration is there is that both simple assault and battery are included in that list in 61104A15. The second bullet point on page 7, whether these offenses should be included in those that would trigger a higher penalty for domestic assault and battery. Both simple assault and battery are included in that list in 62510B2 and 62511B2. And then the final point is whether battery against a healthcare provider should be included in the list of battery offenses that forms part of the offense of unlawful entry into an occupied structure. Under that offense, a person is guilty if, without authority, the person enters or remains an occupied structure and attempts to commit or commits a battery. With that, Madam Chairman, I would stand for questions.
Great, thank you, Mr. Fuller. Questions for Mr. Fuller? How's the committee doing? We did just work heavily, 5 bills. Should be really proud of that. All right, it's a big bill.
Question.
Chairman Olson is ready for lunch. All right, keep hanging through. With that, we'll hold all questions for you, Mr. Hopkinson. I know we have the Hospital Association here. Mr. Hannes, come forward if you can, please, and any guests you may have with you. Welcome and good morning still for a little bit longer here. Mr. Hannes, welcome. If you would introduce yourself and then the folks you have with you at the table, or have them introduce themselves, whatever.
Certainly, Madam Chairwoman, thank you. My name is Josh Hannes with the Wyoming Hospital Association, and if my friends could introduce themselves.
My name is Lisa Harry. I'm a representative from Gillette Campbell County and Campbell County Health Board of Trustees.
Good morning. My name is Arlene Campo, and I am the Chief Nursing Officer for Powell Valley Healthcare in Powell, Wyoming.
Good morning. I'm Tracy Garcia. I'm the Chief Nursing Officer and Vice President of Clinical Services at Cheyenne Regional Medical Center.
Good morning. My name is Nicole Rooney. I'm the Chief Nursing Officer at Ivinson Hospital in Laramie, Wyoming.
Welcome.
Thank you, Madam Chairwoman. And if I could for just a second, Nicole was recently recognized by our association as our Nurse of the Year. So I just wanted to point that out for the committee.
Round of applause. Great job.
She and all of these nursing leaders do exemplary work, and so we're excited to be here. And first of all, thank you for your time in May, and again for having us here again today. We sincerely appreciate the opportunity. And I realize we stand between you and lunch, so we will try to be brief, but this is very important to us, and so we appreciate your attention. I just wanted to take a few minutes before I allow these nurses to speak about their experiences, is to update you all on a few things that we know have happened across the country as it relates to this topic. So one is, just to be clear, violence in the workplace in healthcare facilities is a focus issue for all of our national associations, the American Hospital Association, the American Nursing Association. We highlighted it and had a long session at our conference last week in Laramie, specifically about how to address workplace violence in hospitals and long-term care facilities. I've also gotten some information from our Department of Workforce Services as it relates to workers' comp claims. So between January of 21 and June of 22, there were 121 incidences where there was violence in the way that they break it out is from a hospital, long-term care, I think they call it a general surgery center. But in healthcare facilities, there's 121 incidences of a worker either being attacked by a patient or a fellow coworker where a workers' comp claim was filed. I don't know the amount of money that was paid out on those claims. Perhaps Director Cooley at some point could provide that for us, but wanted to share that with the committee. We also had some information from Press Ganey. There was just a report that came out yesterday. And what they found was that there were 5,000 nurses assaulted on the job in the second quarter of 2022. So this is all across the country. And of course, these are obviously just reported incidents. So for context, that equates to 2 assaults every hour, 51 every day, and 1,739 every month. And like I said, that's probably higher. And as some of these folks will tell you, there's a number of incidents in their facilities that do go unreported to law enforcement. I also wanted to share that another state has recently passed a bill that makes assaults against healthcare workers in healthcare facilities a felony. So Louisiana recently passed Act number 461 and number 129. So this requires a few things. So one is that it requires hospitals to do certain things. So you have to post signage in your facility saying, if you attack a healthcare worker in this facility, you could be charged with a felony. It also requires facilities to have in place violence prevention mitigation programs. And you might hear some of that from what our facilities are currently doing. It also requires their state Department of Health to provide templates for the signage, checklists for creating those plans, and provide some other resources to help facilities develop the plans that they need. And then Act number 129 is what actually creates the felony penalties, and it also creates a new offense, which is unlawful disruption of the operation of a healthcare facility. So LSO did a marvelous memo, excuse me, at your last meeting, sort of outlining the other states and their bills. We're becoming a little bit concerned about how this creates a competitive disadvantage as it relates to nursing recruitment for Wyoming. So if there's these other states that have these protections in place, and we're not just competing with Nebraska and Montana, it's a national market. So we're competing with Maine and Florida to get nurses. And if nurses can go anywhere, doctors can go anywhere, we want to make sure that we have an environment that's enticing for them to come. So I'm going to pause there, and I'm going to let these folks offer their testimony and then come back to me if that's all right.
Sure. There we go. Madam Chair, I personally, before I was a trustee for Campbell County Health, I worked in the emergency room and for emergency services. And you have a tendency to expect certain things to happen because you have unstable patients. But I've been spit on, I've been pushed, kicked, knocked over, had a lot of that. And like I say, you expect that. But these kinds of incidents have increased so much that I have to question, is this enough? What we're doing is not working. We aren't protecting our workers. They shouldn't be subjected to any of this when they come to work. They shouldn't fear coming to work. They shouldn't fear injury, and they should be free to report those injuries and expect something to be done about it. I have some testimony from some people who I work with, who I represent. There was an incident where an off-duty law enforcement officer was angry and upset and started throwing things at the nurse in the emergency room. They should know better. There's incidents where seasoned ICU nurses have been punched, kicked, head-butted by people who are, they're stressed, they're at their worst, they're hospitalized, but they know better, resulting in not only physical injury, but personal injury as well, because this has affected their ability to care for their patients. I feel that we need to do something and do it now. We need to impose stronger penalties and send a message to these people who come into emergency services, into the hospital, and knowingly and purposefully abuse our workers. It's bad enough that we can't get enough nurses, but to have people coming in there and fear for their safety, the hospital should be their first place for safety for anybody, for our patients, for our community. It should always be a safe place. And when it's not even for our workers, there's something wrong with that. So I'd like to encourage some more teeth into this bill, something that, like in Wisconsin and Utah, where they're imposing much more strict penalties for battery, for injuries caused by patients to caregivers. And I'm not just talking about the actual caregivers, nurses, EMS, doctors,
We have to protect those frontline people too, those first contact people. So many of our not receptionists, but our check-in people, all of those, the first contact, those people aren't protected at all. And oftentimes they bear the brunt of an angry patient. I myself have been threatened. You have an angry person come in and says, somebody's gonna pay. Well, you don't know what that's gonna be. I've pulled a loaded gun out of a person's pocket. I don't know what that intention was going to be. It's scary. So I encourage you to look at some of these things that are being put in place in other states and the penalties that they've imposed on people who commit these violent acts against our healthcare workers. They deserve so much more. Thank you.
Good morning, Madam Chairwoman. Thank you for having us here today. My experiences are not unlike my fellow colleagues up here. I was an ICU nurse for multiple years and expected that kind of abuse from patients who had alcohol or drug abuse issues. But what is more worrisome now is we're seeing an increase in people who are not influenced by alcohol and chemicals that are becoming angry, abusive. I had a 16-year-old patient in our hospital who threatened a pregnant nurse. That pregnant nurse has decided not to return after she has birthed her baby. It's just not the threat of violence and the threat of injury to their persons, but also now an unborn child has become more than what they want to deal with in their career and ongoing careers. I fear for the future. I'm very happy that I'm on the closer end to retirement because I don't know that healthcare is going to be there for a lot of people in the future, because we have nurses that are leaving the profession that are my age or slightly younger than I am. And it's not because they want to retire, but it's because they are afraid for their lives and their personal well-being. We have new young nurses who, once they experience the violence and the threats and the verbal abuse, decide that this isn't what they want to do for the rest of their life either. And they look to us as senior leaders to help prevent what they're experiencing every day. And we work very hard to try and protect them. In fact, at times offering our personal safety up for our employees so that they are safe and that we are the ones who are often de-escalating and dealing with these angry patients and their families. So from our perspective, I think this is a larger issue. And I think if we don't do something that is a statement and to protect our healthcare workers, we may not have healthcare workers. And I'm not talking just from the nursing perspective. I'm talking about, again, the frontline staff. I just found out yesterday when I talked to our chief financial officer that our patient financial services gets 600 calls in a 2-week time frame, and 50% of those calls are threats. Because they owe money and they're threatening the organization. So again, it's pretty prolific. And thank you for allowing me to share my information.
Good morning, and thank you again for having us, Madam Chair. I have 25 years worth of experience working in the emergency department at Cheyenne Regional Medical Center. And I too, very similar to what you've heard before, have had multiple assaults on myself, people spitting, slapping, kicking, various different things, been called all sorts of names, as you can imagine, and had threats against my life or bodily harm. And that's very difficult and is very hard to deal with on a routine basis. And I'd like to think that Cheyenne Regional Medical Center, based on some of the information we've gathered, has a very robust security program because our organization at this point can afford to be able to do that. And unfortunately, some of our friends at these smaller critical access hospitals do not have the security that we have. But unfortunately, that is not deterring people from misbehavior in our organization where security is so prevalent. So for example, since we've met, we've collected some data. So within a 4-month period of time, we've had 26 additional incidents of workplace violence. 25 of those were patient events. One of them was an employee event. 13 of those were actual physical assaults. And of those physical assaults, we actually have a security officer in our organization who went out on workman's comp related to that. And then we had 12 verbal threats, a lot of them including threat of life to our patients, our employees. One of the other things that we talked about last time and some information you asked about was repeat offenders. So in our organization, we have the process where we can create what we call an FYI flag in our electronic health record, where we can flag the record and put some information in there that talks about behaviors of the patients that we should watch out for. And in a time frame of about 1.5 years, we had 50 additional FYI flags added to the 179 flags that we already had in our organization. And of those, 28 of those patients have come back to our facility and acted badly a second time. And of those, 11 of them, so less than half of those, actually had alcohol, drugs, or a mental health issue as part of their related issue to being in the hospital. So it's very concerning for us that we're still seeing escalation of this, and that it doesn't appear that our communities are taking this serious. Our most current incident, and we unfortunately had a CNA who wanted to come and testify for you today, but was unable to attend. And she was taking care of a patient in our intensive care unit and was kicked so hard that her eyeglasses flew off of her face outside of the intensive care room. So probably 6 to 8 feet it flew after she was kicked, struck by this particular patient. So those types of incidents are very alarming and concerning to us, and would like to echo what Arlene has stated in the fact that we are really already dealing with a nursing shortage and the ability to be able to care for the patients that need care in our communities. And our ability to continue to be able to provide care that our patients need is becoming more difficult. And when we don't have a pipeline of staff that want to come into healthcare professions or to stay in the profession because they're being abused by patients and their family members, it's seriously going to make one of the healthcare crises of our future, and I'm very concerned about that. Thank you, Madam Chairman.
I would just like to echo my gratitude for being able to be here today to present to you, Madam Chairman and committee. I really don't have a lot of new information to share that my peers haven't already shared, but I would just like to reiterate the importance of this. I have spent the majority of my nursing career on the inpatient side, and in the first 10 years of my career, I would tell you that on the inpatient side, I experienced a lot less violence than my emergency room coworkers. And over the last 5 years, there's definitely been an increase on the inpatient side. 3 weeks ago, we had a lab technician who was drawing blood from a patient who was maybe 10 years older than I was, completely alert and oriented, and because it hurt when the needle went in their arm, proceeded to punch the lab tech in the leg. So those are not things that we typically had seen on the inpatient side, and are starting to see an increase in these type of situations. I have spent a lot of time since our meeting in May rounding on the staff throughout our hospital, asking them about their encounters with patients and whether or not they called the police. And most of the time they have reported that they have called the police and that the police take them seriously. Is what they have stated is that there are times when they don't feel that they're necessarily injured, just assaulted, that they don't necessarily report that. 2 nurses shared stories with me about times that they were assaulted either at our hospital or in their past, and that they felt that they couldn't continue their work, whether they left for the entire day or they left the floor for a couple of hours. They were unable to care for the patients in their charge due to the assaults that had occurred to them. And that's alarming to me. As we face the
greatest nursing shortage I've seen in my 18-year career. It's astounding to think about healthcare providers who can no longer continue their work when we know that our healthcare crisis is not ending anytime soon. Thank you.
Thank you. Thank you all for your testimony. Mr. Hennis, if you'd like to.
If I may, Madam Chairwoman, I think that's a good segue into just my final thought on this. So in engaging with this committee and talking with other people, the question often comes up is that assault and battery is already a crime. And why is this different? And that's certainly true. And if you'll indulge me just a story for a moment, or a hypothetical. If you come into my office and we're having a discussion about something and you decide for whatever reason you're gonna attack me, right? Punch me in the face, I'm injured. Maybe I have to go home, maybe I'm off work for a little while. I can't send my little emails, maybe I miss a committee meeting, right? If you do it to one of these people, like Nicole just said, they're not caring for people that are hurt or sick or require life-saving measures. And we already have a shortage. We can't have these people out. So my answer to how is this different, that's how it's different. The harm, if you attack me, I'm hurt, okay. That's a crime, I can still call the police, that person can be arrested. But if you do it to one of these people, the harm extends beyond to all those people that they care for. You've created an unsafe environment for people that have gone to a place that is supposed to be safe and healing. That's why it's different. We think these offenses should have the option for felony penalties, and that's why. It is different. I would gladly stand for questions.
Thank you. Questions? Co-Chairman Olson?
Thank you, Madam Co-Chairman. So want to explore that a little more and based on a comment that you provided about, what I'm curious about is I think the statement was made that most of the time, at least anecdotally, nurses report to the police if they believe they've been assaulted. And certainly, I think your hypothetical is well put. It is a very different situation that we're dealing with. But my question is, I think everyone on this committee would agree that violence in healthcare facilities is absolutely a problem. I don't think anybody disagrees with that. The question is, how do you mitigate that violence? And if most of the time that an assault occurs, a nurse is reporting it, then my question immediately is, are they actually being prosecuted? And if they're being prosecuted, are they being sentenced? And if they're being sentenced, is their sentence long enough? Because that's what this bill would be addressing, is that final conclusion. And in order for that to make sense, all the other things would have to be true as well. We'd have to know that they're absolutely being prosecuted, because if they're not, then the solution is not longer punishment, it's to prosecute them. But if they're all being prosecuted, and are they getting the maximum sentences provided under the statute? And if they are, then the only other conclusion leads to this bill. Well, then we need longer penalties. But if the first two aren't true, we can't get to the third one. So help me understand, you gave us those national numbers.
Sure.
Not Wyoming numbers, but help me understand what it looks like from the point that it's reported. What do we know?
Sure, Madam Chairwoman.
Mr. Hennis, there was a series of questions in there.
Sure.
One is, I think we heard anecdotally again that when physically assaulted, it is being reported to law enforcement. Law enforcement is receptive, but then what happens next? Are the prosecutors of this state prosecuting those offenders into a conviction?
Madam Chairwoman. So, and Representative Olson. So that information doesn't live anywhere, right? So we did query our members and we've talked about this, and some of them can probably share with you more specific details. For example, one of our members said, yeah, absolutely. If they have an incident that they can't handle, they call the police officer comes, takes them out, cites them, whatever.
that's not consistent across, and I would maybe let some of them talk to you specifically about it, but it's not a place, I don't know the percentage. If there's 100 incidents and 100 are reported, what happens then? I couldn't tell you specifically. I'll lean on them to tell you from real life. I guess, and if I understood you right, I maybe don't accept the premise that even if they are all being reported, they're all being prosecuted, they're all being sentenced, that doesn't mean an enhanced penalty is not warranted or valid. I would argue that it is. And maybe I misunderstood your point. But I would say, if any of you want to share about when you're reporting to police, what happens, if that's all right.
So some of the information that I got from our chief legal officer when we tried to investigate this, and like you said, there's not concrete data that we can actually pull. But what she told me is that enforcement is low, that we would get a victim impact form when they were prosecuted. And over the last several years, we have rarely received any of those.
A couple of responses to that for the committee, for your interest as well, for the public. Obviously, if the crime is being reported to law enforcement, it will be reported in the Uniform Crime Report and collected through our crime databases, not necessarily be your responsibility to keep that data per se, but certainly is involved in our law enforcement data. And then we could have access to those criminal convictions as well. So we should be able to see in our crime statistics evidence of that. But of course, it'd be hard to extrapolate that out from regular assaults and batteries, right? And so how that gets tracked is difficult, which is one of the purposes of this bill, or would be a result if this bill passed, where that data could be more easily extrapolated or identified, those particular types of circumstances. So I think important there, and I wouldn't expect you necessarily to have that information, and it would vary from locality based on local law enforcement discretion as well as local prosecutor discretion in each of those jurisdictions. Representative Washit?
Thank you, Madam Chair. Just a couple comments. One is we in this committee have been talking about the National Incident-Based Reporting System and the migration of police data collection in Wyoming. And that system will give us much more detailed information about the relationship between the victim and the offender, and it will give us much more robust information about the location where the crime occurred. So I think we're right around the corner from being able to fill in some of those gaps on data collection. But I do think it's real important, reporting, I tend to agree, whether you accept the premise or not, I tend to agree with the chairman that if these cases are being reported, if law enforcement is responding and investigating and filing cases, then how they're dealt with in the justice system presently is an important element for us to consider, whether or not we then need to enhance penalties. So my question is, of these 13 assaults at Cheyenne Regional Medical Center that we know of just recently, how many of those were reported to the Cheyenne Police Department? And the lab tech at Iverson who was kicked or punched while trying to draw blood, was that case reported? And how were those cases handled? Because I think it's real important. If we're not even reporting these, then I think that it is problematic to start raising penalties when I would expect if crimes aren't being reported, that there will be more of them. And I don't think we give our law enforcement people an opportunity to intervene. But if I'm wrong, if law enforcement is coming and saying, too bad, so sad, we're not even taking a report, and they walk out the door, I have a hard time believing that's occurring, but if it is, I think that creates a different issue. So how many of the 13 assaults at Cheyenne Regional Medical Center were reported, and the case at Iverson, how were those cases dealt with?
It's my understanding, just for the committee's understanding too, your testimony, all of your testimony has been consistently that when there's a physical assault, not just a verbal threat, law enforcement is called, law enforcement does respond, and law enforcement is receptive. Is that accurate? Generally?
Madam Chair, yes, that is accurate. I don't have the exact numbers on the 13 cases for Cheyenne Regional, but we have a very robust relationship with law enforcement, and when we do call them, they do respond and act appropriately. I would assume, but I do not have the exact information. I have not looked at all 13 cases to see if there was a report filed on those.
Yeah, yeah. We'll go to you and then you. Gillette and Ivanson.
Yes. One of our trustees is a police officer. And one of the things that he's stated to me is that our first responders, our law enforcement, they're trained to deal with these cases of violence. And our nurses and healthcare staff, they're not. They have to depend on the law enforcement, and so they're called after the fact. One of the things that I want to reiterate, we all know that violence is the problem. I think all I want to see is that healthcare workers are afforded the same kind of penalties as far as felonies as our police and fire are afforded. And that's, I think, the important thing here. They should, if you assault a police officer, it's a felony. You assault a fire responder, it's a felony. It should be the same for our healthcare workers. These are your family members and your community members that we need to protect, and they should be afforded that same consideration, in my opinion. Thank you.
Thank you.
Madam Chairwoman, just to answer the question on the lab technician, unfortunately, that incident did not get reported to law enforcement. We found out about it, the leadership group found out about it 2 days after it had happened, when the lab technician requested to not go back into the patient's room. When I had the opportunity to explain that we would like her to report, because we are trying to ensure her safety and ensure the safety of all of our healthcare workers, she stated she didn't feel like she had a voice to protect herself. And I shared with her that that's what we're trying to do here, is to give healthcare providers in all areas of healthcare a voice in being safe in their work environment. Thank you.
Mr. Haddis.
Madam Co-Chair. So two things. One is just to point out again for the committee, reporting or not, we don't have the option to turn patients away, right? They come in the door. If they assault this nurse today and they come in through the emergency room doors tomorrow, they have to treat that person. It's the law, we have to do it. Pivoting away from that a little bit, I'm not sure I mentioned it earlier, the Louisiana law, which I think is different than some of the other states that have passed felony laws, I believe does require facilities to report incidents. It's part of the requirement on facilities, is that they have to make a report.
Senator Kolb.
Thank you, Madam Chairman. Well, thank you for telling me your experiences. I do have a question, though, about the threat of violence. Just I think that's probably in the eye of the person who feels that way. I am very concerned, maybe you can expound on this, that say I came in and I looked at you kind of sideways, and maybe I don't know, I'm upset about something else, I don't know. But you perceived it as a threat of violence, I mean, I'm worried about that bar being so low, it'll turn into I'll use the word, a woke situation where it's perceived incorrectly and someone gets, brought up on charges for looking at somebody wrong. So could you please, I guess, tell me what you feel this means to you? Thank you.
Mr. Haddis, start with you.
Madam Chairwoman, Senator Kolb, I guess what I would say is that when we're talking to our members and to our providers that work in those facilities, no situation like that ever comes up. What we hear about is patients or family members of patients being very explicit in their threats. A member on this panel told a story about a patient saying that they were basically going to wait, not basically, they were going to wait outside and kill that person. And that person's spouse had to pick her up and drop her off from work every day. Those are the types of, nobody has said to me when I talk to our members about this topic that they've been threatened by a look or some gesture that maybe is subject to interpretation. They are explicit threats of violence.
And to address Senator Kolb's question, which I think is what he's driving at, is in recognizing that you've all been in nursing for a period of time, and many of you in supervisory type of positions, have you seen a change in behaviors of new nursing staff about being more sensitive? Or Senator Kolb, would you like to balance that, the woke with the snowflakes, right? Like those types of concerns. Speaking for you, just asking it directly. Is it as a result of the subjective viewpoint of these healthcare workers, or are you seeing a difference in the behavior of the patients?
I'm going to speak a little bit to that, Madam Chairwoman. So at Powell Valley Healthcare, and I would suspect at most of the hospitals in the state, we have what's called an incident reporting system. When we have these incidents, especially if we have to call the police, all of that, that is reported in the incident reporting system, and we do an investigation. So to Senator Kolb's concern, and I appreciate your concern, definitely, because I'm a tough old battle axe, right? And the younger people today may be a little bit more sensitive. I've just been doing this a long time. But to your point, I have never, ever investigated one of these incidents where it was because a patient looked cross-eyed at them, or just because a patient even called them a name. All of these incidences that I am speaking of today have been incidences that are very noteworthy from the perspective of concern to personal safety and concern for the employees at our organization. And they have, I don't know if you want to call it justification, but all of the behaviors of the patient or family members were very concerning, were inappropriate, and should not have ever had happened in our organization or been allowed to happen in our organization. So, and then we document that, our investigation going forward. Oftentimes there's more than one person who has witnessed the incidents, because one of the other initiatives at our hospital is never go alone to somebody who is upset, angry, threatening violence. We always have other coworkers that go to the situation. So again, I do not believe that it's because we have a more sensitive nursing population today.
Further questions, Representative Provenza?
Thank you, Madam Chair. Thank you for being here today. And I am, again, sorry on behalf of the state of Wyoming that this is happening. I think the problem is very complicated. I'm sure you know all those complicated issues, right? It sounds like we've had staffing shortages over the past several years that have come about. We've had a cultural issue in how we talk about healthcare and facts around healthcare. And that has, I think, bled over into your industry and how people treat you. All of that being said, my understanding is that there were 15,000 nurses that went on strike yesterday in Minnesota because of unsafe work environments. And a lot of what they have been talking about has been that the hospitals don't have enough staff there. They aren't maybe paying well enough to bring in good staff to make sure that everybody's doing what they need to be doing. And because of those staff shortages, words are hard, we have an issue with just how folks are interacting with each other. And that's not at all to say that any act of violence against you is at all at the fault of you, ever. It's to say that this is a complicated problem. And I'm wondering, in doing that, you know, we have a law that allows for enhanced penalties against police officers. So if you assault a peace officer, and I asked the chief of police last time if, since that enactment, if they have seen a decrease in violence. And he said, if anything, it has increased. And so I'm looking as a lawmaker for potential solutions to the problem, the root problem, so we don't have to end up having these incidents at all. What are some institutional things that maybe we can help with, perhaps employers, hospitals, or anything like that, that can decrease that? potential just culture issue and threat of violence at the core? I know that's a big question and a theoretical one.
It is a big question. I'm going to have you just pause for a minute in answering that and see if there's any other, give you an opportunity to think about it. Is there any other questions from the committee? Representative Rodriguez-Williams?
Thank you, Madam Chair. Sir, you mentioned that there was 121 incidents that were reported as workers' comp claims to Department of Workforce Services. I'm just curious if you know how many of those 121 cases were specifically filed by healthcare providers as defined in the bill.
Mr. Hannes, if you know.
Madam Chairwoman, Representative Rodriguez-Williams. So my understanding from what they sent me was that they were all healthcare providers inside a healthcare facility. I'm happy to share with you the document that Workforce Services and Workers' Comp sent over with the taxonomy and how they pulled that out. But that was my understanding from reviewing it.
Representative Yen?
Madam Chairman, thank you, Mr. Hennis. I just want to agree with everyone that I think the problem is real. I'm looking at Bureau of Labor Statistics, shows the bar graph, violence against, workplace violence to healthcare workers has gone up almost every year. The concern I have, and maybe to tag on to Representative Provenza, is does the data in the states that you've mentioned that have passed these laws that have enhanced penalties for healthcare workers, does the data show that workplace violence has improved in those states that have passed those penalties? Because if we're going to pass an enhanced penalty, I want to make sure it does the job we're saying we want it to do. Thank you, Mr. Chairman. Madam Chairman.
Mr. Hannes?
Madam Chairwoman, Representative Yen, it's a very fair question. So my short answer is I don't know. And part of the reason I don't know is because most of them are quite new. Wisconsin's was passed earlier this year. The Louisiana bill I mentioned just went into effect August 1st. I think Alaska's might be a year old. So I don't know that there's good data for me to report either way. I think I'd also say generally, and Representative Provenza's question is also an excellent one, is that this is multifaceted. I'm not sitting here telling you that if we pass a law with enhanced penalties, workplace violence in healthcare facilities is going to stop. I'm not trying to make that argument. What I am saying is that it's a piece of braided initiatives and sort of a scaffolding that is a part of what we're trying to do to make healthcare facilities more safe for the people that work in them.
Follow-up, Representative Yen?
Thank you, Madam Chairman. Mr. Hannes, so one thing in just quick Googling that I noticed was that other states have required workplace violence prevention plans. Is that something that all the hospitals in Wyoming do already?
Does OSHA require you to have workplace violence prevention plans? Mr. Hannes, if you know.
Madam Chairwoman, they do not today. There is federal legislation moving through right now that could potentially require that for healthcare facilities. A number of our facilities do have plans in place, and I'm sure they could describe for you what those look like.
Yeah, go ahead.
Maybe. Thank you, Madam Chair. So as he said, OSHA does not require that, but a lot of us have Joint Commission accreditation for our hospitals, and they do have a requirement for a workplace violence plan. I can't speak to the rest of the organizations in our hospital, but I feel like we have a very robust workplace violence plan. So several things that we have done, the FY flag that I alluded to earlier, when we have some of these incidents, the debriefing that we do with some of the employees that a committee does with those employees is very robust. We have actually come up with a contract that we contract with patients, so when they do have bad behavior, that the provider or one of the administration can go and contract with the patient and say, these are the behaviors that you are displaying that are not allowed in our facility, and we would like to contract with you to stop with those behaviors. You can imagine some of those go well, as some of those you can imagine people will laugh in your face and say, oh yeah, whatever, I'm not signing that, or whatever the case may be, and try to tell them that then, that our goal is to try to then discharge you from our facility as soon as possible based on your ability to care for yourself or to get care someplace else because of those types of behaviors. So we do a lot of things with that. We're about ready to put up some additional signage on the outside of our doors that talk specifically about some of those behaviors that are not allowed. So doing quite a few things in our organization, as I imagine a lot of the healthcare organizations across the state are doing. And we are following some of the regulations based on the Joint Commission where we're accredited.
And with that nod of your heads, is it fair to say that the rest of your institutions are doing similar type behavioral changes? All right, thank you. Just save some time there. All right, appreciate that. Representative Washut?
Thank you, Madam Chair. Just a quick question. Do your organizations have a policy that encourages or requires the reporting of assaults to the police? And two, if an employee of your hospital reports a crime like this to the police and has to appear in court, is that employee compensated for that time while they're in court? Is that paid time?
I'm going to direct that at one of you. Do any of your facilities, or just with a raise your hand, do any of your facilities, if you know, have a policy requiring mandatory reporting to law enforcement for violence against a healthcare worker?
Not as a requirement, no. So we do have a workplace violence policy, and it does request that they report through our reporting system. Does not necessarily spell out exactly when law enforcement has to be called, because it would depend on the circumstances related to that, but they are to report that to their supervisor and to put in an incident report related to that, so that we can help determine when it should be escalated.
So let me ask a question a different way. Do all of your institutions have a policy regarding incidents of violence in the workplace to be reported internally within the facility?
Yes.
Okay, so all of yours does that, but no mandatory reporting to law enforcement because that's so fact dependent on those circumstances. Is that fair to say?
Correct.
Kind of. Okay. And compensation for court time for victims.
Yes. Yes, and then our legal team also would support them through that process.
Okay. Further questions for this Representative Provenza?
Thank you, Madam Chairwoman. Going back to the issue of law enforcement maybe not moving forward with the case, or prosecution maybe not moving forward, do your staff report to you that they feel like they're not being taken seriously because they are healthcare workers, that it's related potentially to some issue that the law enforcement officer doesn't side with you on? I'm specifically recalling an officer here, I think in Casper, who had lost his position for some sort of physical assault in a protest against, I believe, masks, something like that. And so I'm wondering is there anything to indicate why they're not doing that, that you can report to us so we can try and figure out that issue?
If you know if you have direct knowledge of that as to why law enforcement or prosecution teams aren't taking further action, do any of you know that?
Okay. Thank you, Madam Chair, if I may. Sometimes people won't report because they're afraid of violating a HIPAA regulation. I think our laws are a way to mitigate conflict and maintain peace. Can you repeat again what you were, because I was thinking about that and I couldn't think. Just short.
What I'm trying to understand is why law enforcement aren't taking the reports to them further.
In our facility, they are. In our facility, law enforcement feels like they respond and they follow through with everything that we can. They get a lot of calls for breach of peace, and sometimes that's all it might take just to bring somebody down. But they issue a lot of tickets, they follow through, they pursue. It's escalated, they know it, and they are very responsive to what's going on in my hospital.
And so again, to reinforce, I think the testimony that I've heard from all of the witnesses in front of us is that physical assaults are being reported just about every time to law enforcement. Law enforcement is receptive and taking appropriate responsive measures. What I'm hearing is that where historically that was sufficient. But now we're seeing an increase in violence, and healthcare workers are asking for something more. But that's no longer working in the way that it has historically. And so they're asking for enhanced penalties. Senator Cost.
Thank you, Madam Chair. I guess the concern I would ask is the fact of a misdemeanor over a felony. Do misdemeanors get a lot less attention than a felony in the courts once they've been moved up to the court position or whatever? You think of a misdemeanor and it sounds like, well, this is a little scuffle or it's not a big deal. You think of a felony as, okay, this is a big issue. If our police and our fire are looking at those violence situations as felonies, and yet at our hospitals and our first responders, it's a misdemeanor, is that because of the nature of misdemeanor compared to a felony? I guess I'd like to know if there's a little difference there, and I don't know who can answer that.
I'll address that to our, to our county attorneys on the committee, I think are important. Did you hear the question? Can you participate? I don't think it's fair to ask the nurses whether or not there's a difference between a felony and a misdemeanor. So.
Madam Chair, I mean, I don't know how to explain to the committee the difference between a felony and misdemeanor. Obviously, there's a felony conviction takes significant rights away from you. You can't vote, you can't have guns. So they're taken much more seriously, much more likely to go to trial. And the punishment can be, of course, it depends on what we set it at, 5-year, 10-year. Prison time is included, where of course it's not with a misdemeanor. So yes, there's absolutely a significant difference between a misdemeanor and a felony.
And Representative Oakley, for some of these, law enforcement comes in, they might issue the suspect a citation. Is that correct? Do you get a citation for battery, assault battery?
You can be cited and released, or you can be arrested. And then of course, I mean, we could set a misdemeanor can be anywhere from 6 months to a year in your local jail, and fines, which we could set up. It's, generally $750. We can go higher than that if we want.
And Representative Oakley.
I'll just say that my thought is that I don't think that it needs to be carved out a felony. That's my thoughts on it. I think recognizing that there's a difference, which this discussion has done, and that it would do if we passed a law, which might make it more likely when it goes in front of a judge for sentencing, to say, okay, we're going to insist on some jail time this time instead of it all being suspended. I think it does highlight the problem and the need, and we can hopefully have that discussion, insist on more punishment, because just because it's a 6-month, let's say, 6-month misdemeanor battery, we could use this to say we actually are going to insist on that 6 months, and maybe they serve 2 months of it or something like that. I think that can hit the problem. That's my thought of it. I don't know that we need to go to a felony. If there's significant injury, again, then that can be used a different mechanism.
All right, great. So that answered Senator Cost's question. Further questions appropriate for the nurses or the hospital association to answer? Representative Swanitzer.
Thanks, Madam Chairman. In education, either in nursing school or in your facilities, is it widely known or assumed nurses are informed there's threats of violence against them? And I guess that's my question. Is there a class in nursing school or some type of program that nurses are trained or aware when they go into the workforce to expect some of these issues? Is my first question.
Madam Chair, Representative Swanser, that's a great question. Thank you. And no, unfortunately, there's not. And unfortunately, a lot of people going into healthcare careers don't have any idea. until they actually are inside the walls of the healthcare organization providing care to patients, which is unfortunate. However, a lot of the organizations and part of workplace violence programs is related to how do we provide training. So it's the burden is really on the hospitals or that healthcare system to be providing that training to their staff. So we use a particular program called CPI, where we train staff to help recognize when patients are escalating, to de-escalate them. And then certain people such as security, some of the staff in our emergency department are actually trained on how to do physical holds of patients as they start to escalate in those types of behaviors. But unfortunately, no, there's not anything that we learn ahead of time about how to deal with that and how to prepare yourself for that.
Final questions before we move on to further public comment. I know there's more, and of course, we are behind schedule. Your committee, final questions for the nurses or the hospital association? All right, seeing none, thank you all for being here. Appreciate your time.
Thank you.
Further-
Thank you, committee.
Thank you. Further public comment? Raise your hand if you intend to provide public comment. Okay, 3. Is there anyone else online? All right. Welcome, Ms. Bush. Please come forward.
Good morning, members of the committee. Sheila Bush with the Wyoming Medical Society.
A 2 for 1. All right.
Thank you. I'm the counterpart to the doctors. I'm Tony Decklever with the Wyoming Nurses Association.
Wonderful.
So I know some of this has been covered, but I'll be brief. I think it is important to know just some quick statistics, and Representative Yen, I know you said you looked up some of these, so this may be duplicative. Healthcare workers are 5 times more likely to be victims of violence. The Becker's Hospital Review recently did a survey. 92% of healthcare workers have been victims of violence. 73% of all workplace violence claims in 2018 involved healthcare workers, according to the U.S. Bureau of Labor and Statistics. And the CDC, the Centers for Disease Control, cites the primary reason, or one of the primary factors for an increase in healthcare violence is the lack of regulation and laws in states. The incidence of violence within healthcare settings between the years 2011 and 2018 grew by 63%, again, according to the Bureau of Labor and Statistics. Representative Provenza, to your question about social, economic, cultural reasons for some of this, the CDC has looked into this a little bit. They cite a number of factors. Those include, a high concentration of poverty, diminished economic opportunities, socially disorganized neighborhoods, high levels of family disruption, low community participation, social and cultural norms that encourage violence, health, educational, and social policies that help to maintain economic or social inequalities between groups of society. I think that's coupled with the things that you mentioned also, staffing shortages, and an overall elevated tension in our society, right? Thanks. So I think, as Josh said, we don't believe this is the silver bullet. That's hardly ever the case when we look at some of these things. We do believe it is an important piece of the puzzle. And we do believe that, I think, just starting at the point of agreeing that healthcare workers are very different. Josh made this point very well in terms of what harm is done to society and the other people within a facility. If a healthcare worker is harmed, their inability to do their work and the consequence and impact that that brings. I think it's important to juxtapose the reasoning that we collectively as a society decided that enhanced penalties for assault or battery against a peace officer was something that was really important. And so in looking at this issue, if we turn it around, if the question today was to reduce those penalties and remove that protection or enhanced penalty for peace officers, what would the arguments be against doing so? And so I think those same reasons that come to mind should similarly come to mind in the question of enhancing the policies and the penalties against healthcare workers. They're very similar in the sense that they're providing a service. They're critical to society. They're different in the sense that peace officers more often than not do have the means to defend themselves. And they have some protection available to them that healthcare workers do not. Our physicians go into exam rooms with scrubs on. They're not armed. They're not trained in self-defense. They don't have that enhanced toolkit or skill set that they would need to be able to defend themselves that way. And so in comparing those things, if the question today was to no longer have enhanced penalties when someone assaults or attacks a peace officer, why would we not then use those same arguments to support the case for enhancing penalties against healthcare workers?
Do you have anything further to add?
Thank you, members of the committee. We've been working on workplace violence, especially for nurses, for a long, long time. This legislature, our Wyoming legislature, tried to do something many years ago, and it did not go through. This has been an ongoing issue. I mean, you hear the stories from the nurses. I am a registered nurse. I have been attacked, and it just is. As Josh also said, it's a multifaceted problem that takes many pieces to fix. So to Representative Yin's question as to does this work, that specifically on enhanced penalties, I tried to find that information also. And again, because so many states, it's fairly new, that they just don't know yet. It's interesting because I'm leaving for Washington, DC tomorrow. The American Nurses Association has their annual get-together with all the lobbyists and governmental affairs group next on Thursday and Friday. This is the topic of conversation, and that was going to be one of the questions that I asked my nursing colleagues is, your state has done this, has it helped? Is it working? Because I haven't been able to find anything either. But the one thing that did happen in June of this year is that there was a bill introduced to Congress. It is House Bill 7961, and it is it's titled Safety from Violence for Healthcare Employees Act. It has been referred to the Judiciary Committee. And in this bill, it refers to violence and intimidation, and it has it also has enhanced penalties at the federal level. So if this bill were to move through the process, enhanced penalties is included in this. So and part of the reason for this is because the states they're not doing what needs to be done to protect healthcare workers. It is interesting that the American College of Physicians did a study on what states are doing for healthcare professionals in this arena. Wyoming is the only state that does not have any legislation that directly talks to protecting healthcare workers. We are the only state. So some states have legal protections for physicians and other healthcare workers. Some have protections for public health officials. Some have existing workplace violence prevention requirements for employers. But the only state that has no existing legal workplace protections in place is Wyoming.
So if you're a nurse, a traveling nurse, of which there is a nursing shortage and we're all trying to recruit, and you're looking across the board and there's only one state that has no protections whatsoever in place, does it make it tougher to recruit nurses to our state?
Senator Nethercott, Representative Zwanitzer, it is a factor. It can be a factor. The number one reason or the number one thing that keeps nurses, because it's not, we talk about the travelers and how expensive they are and what they're doing and why are people traveling. And part of the reason why people are traveling is because if I travel and I go to a healthcare facility on a 13-week contract, then I get to leave. I don't have to stay. I get to leave. I get to go to another place on a 13-week contract. I'm paid well. I do the same work that I'm doing here, but I don't have to stay in a facility that doesn't care about me. I go there, I do my job, I leave. The number one reason why people do leave their place of employment is because they don't feel valued. And that is exactly what's happening in Minnesota when these nurses are saying,
We don't feel valued. You don't treat us, you don't staff, you don't provide an environment that's safe for me. Why should I stay here? And so and COVID didn't make this any better. It really, really didn't. It really put nurses kind of, we have targets because we're the first person that people see or that work with when they come into a facility, and we're the biggest population. So, and our doctors are experiencing the same thing. You hear about the doctors that were killed in the clinic not too long ago. So people are angry, and it's not just the people that are coming in, but it's people that are working also. It's a tough environment right now. So anything that a state can do to show that we value you, we do value you, we take care of you, we want you to be here, we want you to stay, that's all positive.
Further questions from the committee? Co-Chairman Olson.
Thank you, Madam Co-Chairman. Ms. Bush, some jurisdictions have experimented with treatment bans in response to violence. I don't know if you have any experience with that. I'm not saying it's a good or a bad policy. I'm just, curious because I agree. I don't think anyone here thinks this is the silver bullet, but just curious if those are effective or not.
Madam Chairman.
Ms. Bush.
Representative Olson, did you say treatment bans?
They're called treatment bans, yeah, for violence in the workplace. I didn't understand earlier testimony about contracts when that occurs, but obviously private institutions can ban people from their facility if they, and that accounts for like less than 10% of hospitals. Most of them are public or nonprofit, but some jurisdictions have experimented, and the United Kingdom is the most recent with a law that allows facilities in non-emergency scenarios to implement bans. They're usually temporary bans, so like 6-month, 12-month periods when there's reoccurrences of violence by that particular individual.
Madam Chairman, thanks. Now I understand what you were talking about. I didn't have the lingo.
Probably using the wrong lingo.
I'm sure you're right, sir. I think that it's a really tricky balancing act, right? Physicians particularly are bound by a whole lot of principles and ethics around patient abandonment and delivering care and honoring that Hippocratic oath that they take so seriously. I think it's worth exploring. I think all of it's worth exploring. I think that a notation in a record or a healthcare document that says this person has been known to be violent with, those kinds of things, I'm guessing is along that line of reasoning, all have a lot of merit of exploring. I don't have a formal response. I don't know that the AMA, the American Medical Association, or the Medical Society has taken that point in specifically and have a response. My answer would be all of it feels important. And right now, healthcare workers are wildly disadvantaged in the landscape for protecting themselves, and anything that we can do would be helpful.
Okay, committee, this conversation is continuing. It's 12:53, which is good. Debate is active. You seem awake. How are you feeling about, do you want to take a break now? Do you want to finish this topic out, or do you want to take a lunch break? Raise your hands if you want to finish this topic out. Raise your hands. Is there any more testimony? There is. And then debate on the bill. So just kind of gauging the committee. So do you want to complete this topic? Raise your hand if you want to complete the topic.
In 7 minutes.
Raise your hand if you want to complete the topic without taking a lunch break. Raise your hand if you want to take a lunch break. And you have to vote. All right. All right, final questions for these witnesses. Senator Cost.
If I was chairman, I would give you the choice to have lunch.
It might make things a little tighter. You guys are a little loose,
Thank you, Madam Chair. In response to the last question, because we're 16 at least are critical access hospitals, I don't believe that, correct me if I'm wrong, I don't believe they have the right to be able to ban anybody or anything. Is that correct?
Ms. Bush, critical access hospitals, do they have the right to ban patients?
Madam Chairman, I don't believe so. And this would be a much better question responded to by Josh or the Hospital Association. What I do know is that they're bound by EMTALA,
and that requires that they provide care, especially in emergent situations. I do think that the nuance that's important is what Representative Olson is referring to as maybe in clinical settings, or he did mention non-emergent. And I don't know when EMTALA specifically attaches, but I believe it is for emergency situations. And so there may be some nuance and some room there to have the conversation about times where it would be appropriate or ethical and legal to do something along those lines.
Final questions for Ms. Bush, Ms. Declever? Because I told you you were going to lunch. I knew it would work. All right. Thank you. Thank you both for being here. Ma'am, are you okay to come back after lunch? Are you sure? All right. With that committee, and in light of the hour, we'll come back at 2 o'clock, and we will start exactly on time. So 2 o'clock, please be here so we have a quorum and we can get through.